exploring on discrimination within and inequality within the legal systems that revolve around women, advancement of women's rights, and a pursuit of justice. Our panelists will share their experiences, will give us insights on the challenges that they face when confronting the whole notion of women's rights. They will give us insights on strategies on how to redress that, and we'll also have a little bit of discussion on the Maputo Protocol, and with regards to this, we'll also go deeper and discuss within our own legal profession So the whole objective of the session is to, at the end of the day, we need to increase awareness about the persistent challenges that women face in accessing justice, the best practices and lessons that we can learn in advocacy efforts for women's rights. But also, we have to discuss on the strategies for influencing policy changes, advocating for gender-responsive laws. Legal framework is part of our discussion. Legal aid, as well as strengthening the legal framework to protect women's rights. I'm not the speaker, I'm just a moderator. We have a panel of very distinguished experts, and we'll go direct to kickstart the session. I'll welcome Linda, and she will tell us about the challenges and the obstacles faced when advocating for women's rights. Linda will also speak about the challenges that hinders implementation of a full exercise of women's rights. So for those who came late, Linda will lead the talk. She will discuss all the issues on women's rights, and then our panelists will also join and share their experiences on, from different angles that Linda will guide us up. Linda,
Just waiting for the microphone. So, good morning, everyone.
Good morning.
I'm sorry about the delay. We just have to arrange a few things, and I'm glad to see more of you have joined us. Basically, we're aiming for a more conversational style with the ladies and hope to invite you to participate in the conversation after we have a conversation around the topic. So, first on our list, Lulu, if you could just please tell us what the major challenges and obstacles faced are when advocating for women's rights within the legal and justice system.
Good morning. We're having issues. So as we know, and I think most of us who work in this sector or work with women in general or focus on gender, we know there are a number of challenges. The first main challenge, I would say, is our own legal frameworks, and we can have conflicting laws and policies. We could also have situations where you find that the legal environment or the legal frameworks is not conducive to the provision of services to women. I'll give an example. I'll give a direct example. And I remember before we started the session, Linda asked me if I know someone in Tanzania called Rebecca Yumi. So Rebecca is a lawyer, a Tanzanian advocate who took the government to court because of wanted a change in the Law of Marriage Act, which the Law of Marriage Act provides for, has a provision that says that a girl can get married at the age of 15. Now, we have other laws, the Sexual Offences Act of 2008, that says that it's illegal to have sexual intercourse with a minor under 18 years old. So you can see we also have the Education Act that also says that everyone has the right to education. A 15-year-old girl is still in school. So you can already see how the laws, policies, and sometimes the legal frameworks can be conflicting and can then affect women and girls' rights. And it's a good example because it shows how, without addressing these challenges that are within our laws and policies, then we would not be able to effectively provide services to women and girls. So now it went to court. She won the case at the High Court. Then the government appealed. Then it went to the Court of Appeal, won the case at the Court of Appeal. Now, there is a very lengthy process to turn these provisions into law now, to say that a girl should also get married at the age of 18. Now voice in Parliament, and so now we have to convince members of Parliament to agree that, you know, it's illegal for a girl to get married below the age of 18. So these are some of the challenges within our own policies, laws, and legal frameworks that can hinder in one way or another. One of the things that we do at the Legal Services Facility is to ensure that we provide for a conducive legal policy framework, environment, so that we can directly address the issues affecting women and girls in Tanzania. So if there are laws, there are policies, or even processes that somehow, one way or another, will affect the provision of access to justice for women and girls, we address that in terms of advocating, but also influencing the changes in this. And I'll give an example of the law of inheritance, which again is a very archaic old law that does not give a lot of rights to women in terms of inheritance. If we talk about access to justice, one of the areas that really affect women and girls is on matters to do with land, and also to property and inheritance as well. So unless we address the issues of in the laws, the policies in terms of owning land, owning property, and inheritance as well. The translation, it's not working. And I can also hear a lot of noise, like I can't hear myself talk because there's a lot of noise, I don't know where it's coming from. And the translation is not working. Oh, he's trying to, I think we can hear him here, but they can't see him.
Can you go to the back, right next to the booth? Yeah.
So you can try again.
Oh!
Perché su di si manda collega. Faccio collega.
Même si ça marche pas.
Ça marche pas en français.
En français, oui.
What about the equipment?
There's no French. Oh, okay.
I think it's trying to work on it.
Okay, we're trying to work. Alphonse, can you just say that we're working on the translation?
Yeah. Kwa wale ambao wanasikia Kiswahili.
No, don't speak French.
Sawa, kwa wale ambao wanasikia Kiswahili, translation sio nzuri, wanajaribu kurekebisha. Kwa hiyo nafikiri baada ya muda tutaweza kuendelea vizuri na session.
Sasa yote imepita.
Okay. Nitarudia kidogo kama nitengeneza kidogo tu ili nipate. Okay. Kidogo. Sawa.
That's why Swahili is becoming a fifth language in Africa.
It should be. We should all speak Swahili in Africa to make life easy.
Yeah. We have to start teaching, eh?
Sorry, ladies and gentlemen, we just want to resume the conversation. Thank you very much for your attention.
Yeah. Okay. So,
Try again.
All right. We are ready.
it's ready? Okay.
Great.
Okay. So I will continue and I'll try to go really fast now because, you know, to save time. Okay, good. So the first point I was talking about, it was legal laws and laws, policies and legal frameworks that sometimes they contradict and affect women and girls' rights in terms of achieving access to justice. Then there is economic equality. We all know about the differences between women and men when it comes to economics, and that really affects in terms of achieving access to justice. I spoke about land ownership, property ownership, and how if you don't, then you're thrown into poverty. That then affects your economic rights as well. Then there is also political representation, civic and political representation. So the role of women in positions of leadership. So if you don't have, we know that representation is not very good for women in most places. In terms of political representation, we were speaking before as well. A lot of the political parties, the major political parties would have what the so-called women's wings. And I would say we have women representation in leadership, but that is not really true representation, because at the head of the party, where you have the National Executive Council Committee, you don't see women represented at that level. And so that kind of representation, or the numbers of members of parliament, percentages of women, women in cabinet, women in other decision-making bodies. We talk about women on boards, women CEOs, that kind of representation is also an issue. We also know violence against women and girls. We spoke about this as well before. It's a problem because then it also stops women and girls from fully participating. Then we have cultural norms and stereotypes, and sometimes what we call biases that can either perceived or real, that can affect women in terms of participating fully in different sort of settings and different areas. I want to stop there so I give others a chance to talk.
Thank you very much, Lulu. I'll now move on to Chikondi. Chikondi is from Malawi and works for the Clooney Foundation. Chikondi, would you agree with the statement that the main hindrance to women's rights within the legal and justice systems is actually a lack of political will? And if so, could you tell us what your experience has been in Malawi?
Thank you so much. Thank you so much, Linda. In terms of my experience in Malawi, in terms of protecting and promoting women's rights, the biggest challenge within the legal system, I would say that it is the stereotypes within the...
Yeah, because you're not on the mic. I think the mic is not working. I don't know where the... Yeah. Kwa sababu ya mic. Kwa sababu ya mic haiko on. Labda jaribu pia hiyo. Maybe you can exchange it with that one. That one is working.
So I was just talking about my experience in Malawi, and the biggest challenge for me has been the lack of gender sensitivity within the judiciary in terms of understanding the challenges that women have when they approach the justice system. The first part of it would be that women are generally economically disempowered. So, for example, if a woman who is a victim of any sexual offense, if they come before the court and they are economically disempowered, when a woman comes and says, I want to withdraw my case from the legal system, it is the duty of the court to assist, because in many cases, in my experience, has been that women will usually withdraw cases as victims of sexual violence because probably they have been given money by the perpetrator. I remember the case that I did before. It was a sex worker who was raped by a policeman. And we had done a lot of advocacy around the case. And the day that the woman was supposed to testify, she did not come to court. And the next day she did not come to court. And later on she said she wants to withdraw the case. And this was after a lot of investment into the case in terms of advocacy and providing pro bono services. But then I feel like that the duty of the judiciary could have been to assess if it was voluntary on the woman to withdraw, because later on we discovered that she had actually withdrawn because the policeman had given her money. And those are some of the challenges that come within the system where we do not recognize that there are certain barriers that make women not access justice, not just because they do not want to come out and claim their rights, but then there are all these other barriers that come into play. And another instance that I can talk about is a case of a girl who was, it was a woman actually, who was also raped, and then the defendant was saying, no, it wasn't me because I cannot erect. So what the magistrate did was he said to the magistrate that, can you ask any of the women in their garden to come and try to play with my penis and see if I can, erect. So that happened in court, and then the magistrate allowed it to happen, and the victim was right there in court watching this man having his penis being played with by a random woman in the garden. And it went on for an hour, and this man could not erect fully. And on that basis, the court found that he actually did not commit the offense. So, of course, the decision was overturned on appeal by the High Court. But the main issue is it shows how insensitive our judicial systems can be to issues of women, that we allow certain things to happen as lawyers, because obviously the lawyers are the ones that are adjudicating on these matters. So we need to start recognizing that the challenges that women face are beyond what we see on the surface. There are other, interrelated issues that as women come within the legal system, we need to interrogate those issues and find out more than what happens in ordinary cases.
Thank you, Chikondi. I'll now move on to Adobe. Adobe, you work for the Ban Center in the United States. While there have been positive advancements in women's rights and the pursuit of justice, what challenges have emerged alongside these advancements? And maybe just to put it into context, we saw how the momentous case of Roe v. Wade in the US has been reversed. So an advancement had been made when Roe v. Wade was passed, and then we're now seeing a regression. So could you just talk about how the fight for women's rights is constant?
Thank you so much. Thank you. I thought my voice was loud enough. For the interpreters. So when I think about, thank you so much for that question. When I think about the challenges that women face and how there have been lots of setback, one thing I have done over these months has really been focusing on the legal profession itself. So you're going to find that most of my discussion will focus on women lawyers as women lawyers, because I know I'm speaking to owners of law firms, leaders of bar associations, people who can make impact in the legal profession. So I'm going to focus a lot on that. There's lots of progress that have been made. We talk about the idea of, you see in the law firms where we had a lot of women who are focusing more on family law issues, where women are naturally burst into the section of taking family law, taking real sections. We're now seeing where you're having women go into engineering, go into AI, and those other real areas of where we have seen, or where we have imagined over the years to be for the men. In terms of looking at how has it, what challenges do we see, and what has happened in the legal profession, I
bar associations here and bar leaders that a lot of improvements can be made if we focus on our policies within law firms. What policies do we have in law firms to acknowledge the challenges our female lawyers face? Not out of pity, not out of tokenism, but the idea that there are issues that basically affect women. And how do law firms handle it? She was talking about the setback that we saw in the US as it relates to sexual reproductive health rights for women. You also see that play out in a lot of law firms where women are employed and they are being asked. Many law firms do not want to employ young women who just got married because there's a mindset that, oh, she's going to, maternity leave is going to come very soon. She's going to get pregnant. How am I going to deal with that? We've had situations in Africa here where we've had law firms and banks asking people, if I'm going to employ you within 2-3 years, nothing about pregnancy is going to come up. We've seen that. So how are bar associations ensuring that those kind of policies, there are policies that are gender sensitive in law firms? That for me would be a way that I see the challenges being improved. Also, I think I have a survey that was carried out in Nigeria. So the Venn Center run what we call Women in the Profession program, basically supporting women lawyers to speak for themselves. So we see that there is FIDA, a lot of women forums, but many of them are focusing on women's rights issues outside the legal profession, which is very important. But how do we look inwards in ourselves and what we do within ourselves? The Nigerian chapter of the Venn Center's Women in the Profession program ran a survey. They asked the question, talking about challenges, why are we having a lot of women leave law? You know, many female lawyers are leaving law, going into different things. So the question was, why women leave law? I'll just read a part of the survey for you. There were 3 major challenges that were found that women in the profession face. 95% of them indicated work and life balance, trying to balance that at work. 65% talked about gender bias, where you see a lot of insensitivity as it relates to women issues. And 40% of them talked about lack of mentoring for women to grow in their career. Then there's also the 34% talking about unequal pay for women and men. I've also seen issues around, so 1% talked about sexual harassment in the workplace. I also work with women lawyers, women of color in South Africa, and we have focused on advancing women in the workplace. What has been the challenges for women? One thing we have also really seen within law firms are sexual harassment and bullying, and nobody talks about, but those are very deep-rooted women's issues in many of the law firms. So I'm really hoping to use this section to challenge our bar associations, our law firms, to have policies on those areas, and that's really missing. So we talk about women's rights, we talk about land, property, they're very important. But within the profession, it's high time we start looking inwards and start working within ourselves. I'm preaching, I'm going to stop.
So the challenges that women face in the legal profession are just symptomatic of a wider problem of gender bias, inequality, patriarchy, and misogyny. We often say that representation matters. How do we advocate for representation of women so that we see the kind of change that we want to see?
Thank you. Before I answer that, you just reminded me of another survey that was done with law firms in Africa. I think this was done by McKinsey, 2020 or 2021, and it actually says there are more females, girls that graduate from law schools. There are more girls, females that enter into law firms, and they go to the level of middle management, and then there are very few women heading law firms, becoming partners, and actually at the senior level. So there is something that happens right in the middle. Yeah, so I totally agree with also the study that was done in Nigeria as well. So to get back to the question of representation, a number of things. I think representation should not be it should not be something that depends on the whim of whoever is in power. It should not be something that that we just talk about. It should be something that we institutionalize. It cannot happen if it is not somehow set and put it, because we want to right the wrongs and because we want, I don't like to use words like affirmative action, but there is something that we need to do to change the status quo. So if we're talking about women in political spaces, women in decision making, what exactly are we doing to ensure that that happens? So I'll give an example. We are in Tanzania at the moment reviewing the National Electoral Act and also the Political Parties Act as well. One of the things that we want to look at is representation and how that is institutionalized, because you cannot say that you need to have more women in leadership if you're not going to do something to make sure that that happens. So there has to be policies, there has to be systems in place that ensures that, and this also applies to workplaces as well, law firms and also other places. We're talking about, I mentioned earlier about women in decision making in places like women on boards, governing boards, women in senior positions. Again, another research that showed that, oftentimes we think that maybe there is discrimination that purposely keeps women out of these positions. And then I read this research that actually said, when you have a situation where you have a group of people in a room and they've been together for a long time. So let's say one of these very big institutions or company or, organization has this governing board, and the whole governing board is men of a certain age in that governing board, like the whole of it. And then it so happens that there is a vacancy for one person, because one person has left, one person has retired, one person has, the tenure has ended. And then the people who are in that space, what happens is they will look at each other and say, we need somebody else to replace the person who has left. Do you think that they will think that we need a young female person to come and join us? They will look for someone who looks like them. So unless there is something in there that actually says you have to have 20% of women represented, you have to have 30% of people of a certain age represented, it will not happen. So there is a role to, there is a need to make sure that there are actual, how can I say it, maybe policies, but also processes that will somehow make sure the change that we want to see happens, because it won't just happen.
Thank you, Lulu. I can see Lulu thinks affirmative action is a dirty word, so let's talk about it. Let's talk about it. Adobe, you live in the US, and recently the Supreme Court in the US has held that affirmative action in terms of race is unconstitutional. By implication, that should apply to gender as well. In Africa, we have the Maputo Protocol that promotes gender equity, for example. What are your positions on affirmative action for women to redress the inequality and biases that we experience in society?
Interesting. You know why it's interesting? Because we look at a place, many of us sit back here in Africa, we think the US has got it all. But over time, we're beginning to see that we're all the same, just that institutions function more better than the others and things are different. So as I do this work every day, I just realize that really our challenges are all the same across the board. In terms of affirmative action, I had in my prior life really worked on it a lot, stemming from CEDAW and the idea that it is important. It's important for us in Africa to focus on it for women, affirmative action for women, because of our history and where we're coming from, our culture, our orientation over the years. There's a lot of improvement, but we're still not there. I know that when I was pursuing for a law in Nigeria that was going to be called Equal Opportunities Bill when I was in Nigeria, trying to get that law passed because we wanted to get it as a way to domesticate the CEDAW in Nigeria. The lot of backlash was, what are they saying? How long are we going to give them that 5% seat in the parliament? How long will that last? Who is it going to get there? But we have seen in countries like, I think it was Yemen that passed it, that has it, right? Yes, where we're seeing the difference it's making. And not just, so for me, when I talk about affirmative actions, I don't want to restrict it to the political space alone. I also want to include it in other spheres of our systems, in our law firms, in our offices. How do we create that space that says we must have 5 partners, 3 must be women, or 2 must be women? We don't call it affirmative action, but it's something that can happen. At the Bar Association, how are we sure that we're not having male presidents over and over the years? How do we ensure that we also create that space where women are able to vie for that position and are supported to vie for those positions, and not just give them tokenism of them managing the women's section? I really believe in affirmative action. I've seen it work where it has been allowed in few spaces. Yes, there's a lot of there's so much lack of political will in the political sphere. But I think if we must, I always believe that if we must get it right at government, we must begin in our own little areas of sphere of influence to begin to make those impacts. How do we as bar associations, as law firms, as our women organizations, as our NGOs, how do we begin to create those affirmative actions to make sure that we get women into those key positions of authority, and then we can then look up.
Do you want to say something else?
Yeah, I think she touched on a point. I'm so passionate with the legal profession, and I keep on insisting that we really have to look inwards ourselves. I mean, we can't. This is not working. We really can't speak for the outsiders when if we can't reflect inwards ourselves. I've been following up on statements by UNDOC, UN Women, and they're trying to provide an overview of the situation of women in the legal profession. I really believe that as lawyers, as bar leaders, as law societies and bar associations, we have to produce information on yearly basis. I really like what is being done by the Law Society of England Wales. On a yearly basis, they provide disaggregated data on women, age-wise, income-wise, position-wise, in the law firms, in various sectors, as in-house counsels, and all the sectors that women work within the legal profession. I think in Africa, this is something that we are missing, and it's the right time that we have to look upon. We have to look into it. I was reading a statement by UN Women, and they are showing how when we influence, when we advocate for women to be in positions like judicial, offices, to be in police force, to be in welfare offices, social welfare, how that impacts the justice system as a whole. Women will look at justice issues at a different angle from what we would as men. And if we have more women in more decision-making capacity within the justice system, I think we will be able to change so much, and we will be able to bridge this gap of inequality that we are talking about.
Thank you, Alphonse. And maybe just to mention, there's an excellent study by the Institute of African Women in Law that has collected data on gender representation within the legal profession. So these are things that are already being done. And I think they looked at Senegal, Kenya, Nigeria, and Ghana, I think. Yeah, South Africa as well. So Chikondi, can you tell us of any success stories that you may have come across in your work of advancing women's rights and how we can scale those up across the board?
Thank you so much, Linda. For Malawi, I think in terms of the legal framework, Malawi. So I was saying that in terms of Malawi, the legal framework, we have seen a lot of changes in terms of the Gender Equality Act, which actually specifically provides that women representation in public offices should be 40%, a minimum of 40%. We have seen also the law providing for criminalization of sexual harassment, the requirement that all public institutions should have sexual harassment policies as a requirement, and also gives remedies to women in terms of criminal and civil remedies for sexual harassment. We have seen changes in terms of the Divorce and Family Relations Act, where the age of marriage has been put at 18 for girls, which used to be 15 before that. And also we have seen, and this is the state act, we have seen that women have, even where there is an intestate, women still have power to inherit and the right to inherit property. So in terms of the legal framework, I would say that there's been a lot of change. Even with the Prevention of Domestic Violence Act, we have seen a recognition of violence in different forms, physical, emotional, economic, even for a husband to stop the wife from working. That is regarded under law as economic domestic violence. And a woman can go to court and ask for protection for protection where a man is not allowing her to work. So you can see that there's really beautiful legislation in Malawi that has developed over the years as a result of advocacy. And one case that stands out for me was a case that happened in 2020 where some women, 18 women, were sexually assaulted by policemen after a policeman was killed in the area that the women were coming from. So as the police now decided to fight back and went into the community and raped girls and women, 18 of them. And when that case happened, it was at a very difficult time because it was during elections time, and there was no commitment from government to hold the policemen accountable. But we saw women lawyers standing up for these vulnerable women and challenge the act that had happened against these women, took the police to court, demanding protection of these women, and the court actually upheld the rights of these women and ordered compensation for the women. Although until now, the case in terms of criminal investigations, there hasn't been any. We know that in terms of the standard of proof in criminal matters is very high, and in this case happened now 3 years ago, and some of the women were also threatened. They couldn't go and give statements on time. So in terms of progress, indeed we have done a lot, but I feel that there is still challenges, despite all these beautiful laws that I've mentioned. In terms of women realizing their rights is still a big challenge. In terms of like child marriages remain a big challenge in Malawi, despite having the law that puts the age of marriage at 18. We have certain communities where the parents, the traditional leaders, everyone accepts child marriages and people cannot do anything about it. Even though as even activists, you know that this whole community, they do, as a matter of practice, have child marriages, but you can't do anything about it because it means sending all the parents to prison because it's a criminal offense. It means sending all the community leaders to prison. Then what happens to the children? Who stays with the children? Because there are no systems to protect those girls if they are taken away from their parents because they are promoting child marriages. So you find that the fight to say let's have beautiful laws may not really translate into the change we want. I think the approach has been top bottom in terms of dealing with the challenges, but I feel like we need to start from the grassroots level because if we make all these beautiful laws and they don't translate into anything at the community level, then really we haven't done anything in true sense.
Thank you. Lulu, could you tell us how partnerships between civil society organizations, governments, the private sector can be leveraged to advance the cause of women's rights?
Thank you. I think there are a number of ways. The first and main ways that it could be leveraged is in terms of influencing. If you have very good partnership, and I'll give an example of the way that we work in Tanzania, the partnership that we have with the government, the kind of engagement where you're able to sit at the table and actually influence the changes that you want to see. Having such partnership is important because then you're able to push the agenda, whatever that agenda is that you want to push through. So one of it could be having an opportunity to sit at the right places, the right spaces, and to be able to influence the change that you want to see, whether it is with governments, with the private sector, with the stakeholders. But having the opportunity to engage at that level helps you to further push the agenda. The second one could be in terms of coordination. So when you have a network of a number of partners working together to address a certain issue, we all know when you work as individuals, when you work as separate entities, organizations, it is very hard to address certain issues. It seems like it's your agenda, but when it's our agenda, people will listen to a collective voice rather than individual voices. So the partnerships are important in that way. I'll give an example of a network that we have, which is the Eastern Horn of Africa Paralegal Network, which has about 9 countries. And when we meet as a network, we do a number of things. One is to look at whatever advancement each country has made in the area of legal aid services and access to justice, and then see what has been done in terms of changes in policies, changes in law, in terms of influencing government to get to the position that we have gotten to. A number of the countries now have the Legal Aid Act, legal aid policies. A number of countries now have, paralegals recognized as a cadre within and also accredited within their localities, within their countries. And that is because we have, for a number of years, have been meeting and sharing best practices and what we're doing in different countries. We also share research and research findings in terms of the access to justice and working with communities, but also women and girls, and to see what has worked, what can work, and how the findings can be used to inform policy change and to inform implementation as well, and strategically positioning ourselves so that we're able to affect the changes that we want to see. Sometimes the partnerships can also be used to mobilize resources. It is easier, and now a lot of funders want to see consortiums. They want to see organizations. You know, you have a certain strength or niche, then you work with somebody else who has another niche. Don is looking at me, we've spoken about this before. When you get together, you're stronger. You can then influence and even be able to raise even, bigger pots that can then go towards helping even a bigger number of community, women and vulnerable communities as well. So it is easier to convince the funders, to convince the people who are going to give you the support if you join together and put efforts together in terms of collective effort, but also showing the different strengths that each partner brings to the table, and then also the collective impact as well. Together you can imagine if we are able to reach about 7 million people every year, 10 million people every year with legal education. What if we brought in other partners who can reach, an even bigger number, and then we together come together and come up with a program that then addresses the needs of the community at large. So I think collaboration is really important in that sense. Even with advocacy as well, we talked about policy and advocacy. You need collaboration for that as well. Thank you.
Thank you, Lulu. Chikondi, could you tell us about the Maputo Protocol and how that can be used to advance the rights of women in Africa? The Maputo Protocol is a protocol under the African Charter on Human and People's Rights.
Thank you, Linda. In terms of the implementation of the Maputo Protocol, I would say that the biggest challenge is what I've said when I was talking about the experience of Malawi, because I find that to be one of the best piece of legislation at international level that should bring actual change in terms of women's rights, and when specifically to sexual and reproductive healthy rights. But you find that I was actually really disappointed when the issues of termination of pregnancy bill came to Malawi in Parliament. The levels of how people and the parliamentarians debated against the bill, and how the church came so strongly against the bill itself, to the point that women's voices were silenced, and it is a big no, and for me that already shows how it is difficult in our African setup, where we go out there, come up with beautiful laws, and then when it comes to domestication of those laws, we have these huge barriers within our legislative framework. Because if we had to look at the Maputo Protocol itself and implement in our national laws, I think issues of women discrimination, sexual violence, protection of women, autonomy, all of those things will become a reality for many women. But because we have issues like culture, issues of religion that are not questioned, because you can even see in the Pentecostal movement where people are doing funny things to women in churches, and as the legal profession, we are not doing anything about it. We have all these laws that can help to protect women, but people don't just do anything about it, just observe, because there is this level of protection that is around culture, so much that our national laws actually allow certain things to happen because in the excuse of culture and religion. And that has made the implementation of the Maputo Protocol a big challenge in many of our jurisdictions. Because if we are going to make the changes and make Maputo Protocol a reality, we need to start questioning these things. If we are in democratic, human rights, democratic societies, we need to understand that women's rights are human rights. And being human rights, we need to call out certain kind of actions that are taken by our lawmakers, our leaders, so that when we do that, we are able to implement the laws that we make. Otherwise, the whole idea of protecting women's rights is just going to be something that we'll sing over and over the years and come up with beautiful legislation that translates into completely nothing for the women on the ground.
Thanks, Chikondi. And lastly, before we open up the floor, Adobe, we often say that representation matters, but I don't think we do a good job of saying why it matters. So in your own words, could you tell us why it matters to have gender equity and equality?
Thank you very much for that. Before I answer that, I think I want to go back to the person of the Maputo Protocol. I think it's a very important tool that many of us have not really harnessed. As you know, the Maputo Protocol is the most comprehensive regional instrument that we have on women's rights in Africa. As of last month, about 44 out of the 55 African Union member states have ratified the protocol. And it's time that we as lawyers begin to give life to that document. A lot of organizations are doing extensive work, and I've done some work with the Initiative for Strategic Litigation in Africa, that's Islam. And I know PALI is doing the same, really looking at inheritance issues, family law issues, environmental rights issues, climate change issues, and how it affects women. And not just talking about it, but taking trainings on it, training lawyers from different countries on it, but at the same time looking for how to give life through the legal systems. At our national levels, at the regional mechanisms, we can seek advisory opinions, we can actually litigate properly. So I'm really calling on PALU, I'm calling on the law firms here, I'm calling on the bar associations. You will say, yes, I've been all over the bar association. I think that is a body that has not really, that needs to do more. We're doing a lot, but we need to do more. So I think a lot of us as we live here, let's please go back to the protocol and look at it again. It's extensive, it's massive, social, economic, cultural, environmental. Talk about any rights. You can find something in that protocol that can give life to all those issues we have talked about today. So let me go back to my question. So in terms of representation, one thing I have done in working in Africa, in South Africa, based on the historic issues of South Africa, I have worked with women of color in a project we called Advancing Women in the Workforce Project. And the idea for us was, how do we ensure that women lawyers are represented, not just, as she talked about, at the middle class level, but you want to see women at the top. And not tokenism, not where they're just giving associate partners, where they're giving the real roles. So we looked at it and said, we talk about this, we know about this, but how do we begin to give life to it? So we approach it in different ways. We set up a mentorship program for women, because I think that's something that's so missing in many of our organizations, is how do we support the younger, I think the younger me, okay, even like, I still feel very young now, but I know I'm getting so old. But I think about the younger me having a senior lawyer I can refer to all the time, who is there to guide me and hold my hand, who serves as a sponsor and as a mentor. How does that help? I'm really seeing the impact in the mentorship program we run in South Africa. Beyond that, we also thought about training, so the trainings emanate from the younger ones. What are the areas that they really need the training? So we don't just sit back and talk about it ourselves. Where do they need the training? I've also known about a law firm in South Africa, Bowman's, that do what they call reverse mentoring, where the younger ones are mentoring the senior. A younger female is mentoring a senior male lawyer. And I found it very interesting. I haven't really engaged, but I think that's something that can be looked into. We also look at survey. So he was talking about data. A lot of us are doing so much, but there's no data. If we must talk about these issues, we must be able to put figures to what we speak about. Because we know all this, we've been talking about women's rights for God knows how many years. But can we begin to put figures to it? As bar associations, do we want to think about a hub? So in Kenya, for example, I worked with two universities. We set up what we call the Pro Bono Institute of Kenya, which is a hub that connects NGOs who work on the ground with law firms, creating pro bono avenue for law firms to have diverse areas of working on pro bono issues. But most of the time we talk about pro bono in Africa, we're thinking about one-man litigation, we're talking about the big firms taking on pro bono cases that are diverse. Could we use that hub through the law association, through the bar associations? Then in that way, we are able to provide real-life data to say in this year, 7 law firms, 20 law firms, 50 law firms handled this area of women's rights. And can we stratify within that to say, this was family, this was environment, this, so we have those real data. So we just don't speak. We're able to have things to show to what we speak. I'm challenging Paolo because I know Paolo is here, and I know they can do a lot. To look at law, to look at bar associations. There is the UN mechanism for independence of the bar association. John, I know we've spoken about this. But how do we make our bar associations independent, that they can be a voice? Have tools, not just being a voice, but having tools to bite. Having tools to be able to function. How do we create alliances? How do we create partnerships that we can be able to work with bar associations, to work with law firms, to work with CSOs, to work with private sector, to create those circles that can then support these issues that we're talking about today. I think that's something that we can take away from here today. Sorry, I'm not time for cheese.
Sorry, we need to open up. We're just about to wind up, so we need to invite questions from the floor. It's very short.
Yeah,
Go ahead.
I just like to echo that Adobe spoke about the Maputo Protocol, and I want to insist that this has to be an African agenda. It's an African agenda, and it's a shame that the law societies, we have not embraced that to the fullest. I want to challenge as well, Don is here, with that, Paolo, we have to look at how the legal profession is building jurisprudence on around the Maputo Protocol. We have to produce data and information across the continent, and also Lulu is here. She's the chairperson of the Female Lawyers Association in Tanzania. I know across the African countries we have female lawyers associations. I think this should be a key task that we look at how our courts, how our lawyers are building jurisprudence on the Maputo Protocol. It's very comprehensive, as I always say, but we have not fully utilized that protocol.
Thank you so much. We'll now open the floor. I see a hand at the back there. Yes, madam. Could you introduce yourself and ask your question?
Yes, I'm Barbara Simmons from the National Bar Association in the U.S. This has been wonderful, and I wanted to support what my sister said in terms of the need for us to recognize that we
Use the mic so they get the translation. Yeah.
No, she can see it, it's okay.
Should I start from the beginning? Yes, please. I'm Barbara Simmons from the National Bar Association, USA. I want to thank my sister for her point that it's very important for us to recognize that we, whether we are living in the U.S. or wherever, that we as women lawyers have common struggles. So in terms of the affirmative action piece, I would commend to everyone that they read the dissent of Justice Ketanji Brown Jackson. One of the things she mentions is that the United States has never been colorblind. I also want to make you aware that the greatest beneficiaries of affirmative action in the United States were white women. The other thing is that we are made to feel as if there's something wrong with wrongs being righted. So we have to stand strong. So that's why it's important for us to work together. And also, this notion of using religion to justify wrong, we have to stand against that. And finally, just at breakfast this morning, I was talking to someone, and we came to the conclusion that we have to collaborate together. And when we talk about doing a number of projects, we can jointly, and that's why we're so pleased to be in the agreement with PALU now. Because for us, that wasn't just a piece of paper signed, but we plan to put in action some programs that will benefit the world, really, to create the Africa we want. Thank you.
Thank you very much. Let me just add that I have heard that there's a countersuit by some civil society organizations in the US challenging legacy students, people who are privileged, who are wealthy and get access to Ivy League colleges purely as a result of being wealthy.
And I forgot to mention that because they don't want color affirmative action, supposedly, or race-based, but they have no problem with if your granddaddy and whoever else was able to do something, that's okay.
So it'll be very interesting to see what the result of that case is, and whether, as a result, you know, one of my favorite sayings, I forget who said it, but is privilege. People who are accustomed to privilege feel like equality is oppression. I'm just paraphrasing here. So it would be very interesting to see if they change their minds once their privilege is challenged. I saw a hand at the back there, the gentleman, then I'll take this lady here, then I'll take this lady here, and then I'll go there. Thank you.
Oh, thank you so much. And thank you for identifying me though I'm at the back. That's gender equity. So, my name is Honorable Tuamo Mutinda. I'm a young member of parliament in the Zambian parliament. And I'm privileged to be here. And thank you so much for the presentations that have been made by the women and the only man who is seated in front there. Perhaps my comment is on from all the conversations I could hear how we want the right roles and also providing affirmative actions in advancing gender equality and in managing the various biases that exist in our society. But I also want to hear a comment on how do we also become deliberate in addressing the barrier to actualization of gender equity, who is the man? Because ultimately, the greatest barrier, even in the law of fraternity, are male lawyers. The same with, in the parliament, it's the male parliamentarians like ourselves who would be barriers to most of these affirmative actions, like the example Chikondi gave on the Termination of Pregnancy Act, which in Zambia can't even attempt to bring it anywhere closer.
Sorry, comrade, I'm going to request that you keep it brief so other people also have a chance.
Thank you so much. So basically, perhaps I would just want to hear a comment on how do you also become deliberate in engaging men, because they are the greatest barriers to most of these issues we are discussing, because we might be talking to ourselves. Thank you.
Thank you very much, Paul. We're blessed to have you, and as discussed, political will is probably the greatest barrier to most of the challenges we face. The lady over here.
Thanks. Hi everybody, my name is Vanya Carr. I'm based at the University of Cape Town in South Africa. Mine is more a comment rather than a question. I'm currently working on a research project that looks at sexual harassment and extortion in the courts. We started the project in South Africa and Malawi. And the project was really stimulated by the IBA report that was done in 2019 about the amount of sexual harassment and extortion that's in the legal profession. So I was just concerned that was not really raised in the room today, that the fact that women lawyers are subject to enormous amounts of sexual harassment and extortion in the workplace. and what bar associations are going to be doing about that, I think is quite important. In South Africa, they've started to come up with sexual harassment policies for the bars, and I'm just wondering if that's something that's happening across the board. Thank you.
Thank you very much. I'll have Dorothy answer that, but she did mention it earlier on. I'm not sure at what point you came in. And we're just taking one more before we allow the panelists to respond.
Good morning, everyone. My name is Rowan Konjo. I'm an advocate from Nairobi, Kenya. I run a law firm by the name of JNO Advocates, and I'm also a policy expert in the business reform space. So my comment will be specific to the private sector experience. So for the Kenyan example, I think in terms of legislation, we've done very well. We even have it in our constitution. We have statutes. We have a whole constitutional commission that's supposed to ensure that the two-third gender rule is abided by. But then when you come to the ground, our experience, there's at least 1% of women who own property in Kenya. So translate that to the businesses, to the positions. I'll give you a good example. Just the other day, they made an advertisement for a chair of the Central Bank of Kenya, and the shortlist was entirely male. So of course, as women in this space, we came out loudly and said, what is this? Why is this happening? They should re-advertise and all that. And how many women are we actually building their capacity to be able to take up such positions? When we talk of ownership of capital, are there historical issues that we need to address to make sure that these women can participate at the same level? Even in our law firms, in our organizations, do we subject women to the 16 hours of work that their male counterparts do in order to make it to partner? Is the environment friendly enough for me as a young woman of childbearing age to be able to raise my 5 or 10 children and still giving the same input that my male counterpart is giving? So I think beyond legislation, which I think Kenya has done an excellent job on, there are still some very historical issues that we need to look at to ensure that in terms of implementation, that we're not just doing it as a theoretical thing. Thank you very much.
Thank you very much for those questions and comments. I'll just repeat them and then ask each of you to respond. So Honorable Mutinta asked, how do we become deliberate about breaking gender barriers for women? So Chikondi's going to answer that. Then we'll to the next one.
Okay. Thank you so much for that question. I think partly that question was addressed by the panelists when they were talking in terms of how do we deliberately address issues of bias. For me, I feel like as a legal profession, when we were going through the law school, our basic training on constitutional law and human rights, when it comes to issues of women's rights and very other controversial issues like LGBTI issues, you find that as lawyers we forget all our training, you know, and that is why we are where we are, because I'll go back to the example that I gave about termination of pregnancy bill. If we as a profession, when these things happen, and as lawyers, because we know that human rights are universal and it doesn't matter who you are, whether you're a man, a woman, the rights are the same. So if we take that as a basis on which we approach issues, then as bar associations, if we have situations like that where issues of sexual reproductive health rights of women are being curtailed, what are we doing as bar associations? Are we just bystanders and commenting on our social media pages or just discussing in our circles and not doing anything about it? Because for me, I find that if we have to deal with the biases, it has to start with us lawyers, because we are more empowered. We know the law, we understand, we're fully trained, we know these things. The common man, always, they will know about the culture, they will know about religion. That's how they will think. But for us, we've been privileged to have that training to understand these things better. But you find that within our profession, we are not deliberate. You know, it's the same thing that we were talking about when we came into this room and we're saying, why have we been given this small space? It's because we're not deliberate. Because we look at these things and maintain the status quo and do not want to address the challenges that women face. So as a legal profession, and I'm also addressing to Paulo, is that let's make women's issues the main agenda. Because we cannot just have laws and things that don't bring change. If we have to bring men on the table, they have to hear it. Even in our training, you find that in law schools, human rights and gender issues many times are optional courses. How do you expect those lawyers, when they go and become magistrate, judges, head all these institutions, how do you expect them to address the challenges that women face? We need to be more deliberate. And for me, it really hurts me when I hear lawyers being anti-human rights and women's rights. And when you are a woman who is speaking up against inequalities, they put you in a certain category. And then women start even feel more marginalized because they're speaking out. What are we doing as leaders of bar associations to make sure that women's rights issues are on our agenda deliberately? And as women ourselves, are we just going to keep quiet? Are we just going to allow things to happen the way they are happening? Because if we don't do something now, 10 years, 20 years from now, we'll still be in the same place.
Thank you, Chikondi. I'll also add to the Honourable at the back there that Chapter 1 Foundation has challenged the government's lack of female representation in political appointments, and we've taken the case to the African Commission under the Maputo Protocol, so hopefully we'll see some barriers broken down. Adobe. I think this is the question on sexual harassment and extortion.
So I'm just going to mention that I like when I hear we've taken it to court, we're in court, we're doing something in court. It makes me happy because that's the strength we have as lawyers. And I've always told people I work with, I'm very happy to, at the Venn Center, to support organizations to really look at international mechanisms, pro bono, free. So you're litigating on something, now I'm doing advert that I have to. If you're litigating on something I think is important, and you want to have regional and international mechanism as persuasive instrument, as persuasive arguments in your filings, I'm happy to really support on that. Talking about sexual harassment, you raised a very vital point. I'll start with telling you that so when I joined the Venn Center many years ago, I was made to go through sexual harassment training as a manager, separate, and then now as a director, separate. So there's different trainings for leaders, and there's different trainings for juniors. And it's compulsory. Everybody must attend. And it's very participatory, so you can't just be docile. That got me thinking that many years of me working in Africa, I never had to go through that in any of my organizations I've worked with. So I realized that really it is something that is missing. Second, when I started working in South Africa with women of color, many of them talked about sexual harassment and bullying as one of the major challenges that they go through. Is that unspoken thing that many lawyers go through? And they are told, you know that's how it is, just ignore him. We're used to that, people get used to it. Currently, she asked me about the survey from Nigeria where 1% was a sexual harassment. Many of us found it very strange, and I know that's something that we believe. But I believe that many of the women felt balancing work, family, and life issue was a bigger priority for them. Currently, in partnership with PALU, the Initiative for Sexual Harassment Initiative for Africa, I hope I'm getting it right, we are conducting a study of 24 countries in Africa, looking at the legal framework as it relates to sexual harassment, not just in the bigger policy, but also within law firms. So asking within bar associations, asking what does the bar associations have? Because we are realizing from the cases I've worked on that a lot of law firms are using NDAs, that's non-disclosure agreements, to really to affect a lot of women. There's a current case I'm working on where the lady was made to sign a non-disclosure agreement when she has been sexually harassed in the law firm, has raised that with the HR when she was resigning. And so right now, she was made to sign a non-disclosure agreement. The law firm is filing a slap suit on her, which is ongoing, where they use suits to to distract an issue. So that's something that I'm working with an NGO on. I find it very big, but I think it's very important. So I would say that sexual harassment and bullying is a priority for many of the bar associations. I haven't seen that work. I'm hoping that once our research is out, is finalized, we're working with an international law firm and OVRI. We're working with different national law firms in those 24 countries to come out with real life data on where things are. Well, then the next step for us would then be to go to bar associations to ask them, what do you have as policies? Beyond just having those policies, what policies exist within law firms? How do you monitor it in law firms? So it's not just one of those documents that people just do and put on their website. Are there monitoring mechanisms? So we're going in stages. Right now we're still at the research level, or we come to the implementation level. So you hear more of that as the day goes by.
And lastly, Lulu, maybe you can just touch on Ms. Ikonjo's point about the private sector. Kenya has a great legal and constitutional framework that promotes gender equity, but somehow it's not translating in the private sector. Is that your question?
Thank you. I actually wanted to say, before I respond to that, hearing everything that everyone is saying here, and my sister just took the words out of my mouth, we do have to be both deliberate and intentional. And without that, nothing can happen. It doesn't matter what good laws, legislations, policies, processes that we have, if we're not deliberate and we're not intentional about gender equality, it will not happen. And it's not just in the legal profession. The issues that you were raising, especially in the private sector and other sectors, we have the same issues. And I think they're across the board, across Africa, globally even. Not just within the legal profession, but when we talk about women. If we're talking about women in the economic setting, women in entrepreneurship, women in business, it's exactly the same issues that we're facing. Now, having the law in place, having a policy in place is one step, a very good step. But implementation of that is another important step. I like the idea of making sure that we have the data to support our advocacy. Evidence-based advocacy, we cannot advocate if we don't have the evidence, if we don't know what the extent of the problem. We talk about how we want more women in these positions, but what is the baseline? And I know you spoke about very good research that has been done. We need to do our own research as well, individually in our own countries, with the different sectors. We need to have aggregated data that actually shows us, and maybe find a way where people can report annually or something like that, so we know if there is a change that is happening. And then we're more informed, then we're more intentional in terms of the changes that we want to make. So it cannot, as I said before, it cannot just happen on its own. Goodwill is important, but it's not enough. Political will is important, but it's not enough. We need to have something that actually pushes the change and facilitates the change that we want to see. And that is us, all of us, being intentional about it. We talk about lawyers, we talk about human rights, we talk about things like that. Yes, it's optional for a lot of people. Not many people studied human rights. But it is our role, it is our responsibility to ensure that the changes that we want to see, that we speak about, we are actually the people who are affecting those changes. Because otherwise it will never happen. It begins with us, nobody else. We cannot be bystanders, we cannot talk about what we don't like that is happening without doing something about it, basically.
Maybe just to add on with regards to Mr. Ikonjo's point, the case that my organization has taken to the Maputo Protocol, when it was being argued in the domestic courts, because the government relied on a clawback in the constitution that said that the implementation of equity in terms of political appointments of women had to be done as far as practicable. That's the phrase. And so we demonstrated that there were women who were available and weren't chosen. We also talked about youth and the disabled people. We demonstrated that there were youth, there were disabled people who could have been appointed and weren't. So in respect of your issue in the private sector, I doubt very much that there weren't women who had the right caliber, they just weren't chosen. And it's back to what we've been talking about gatekeeping and people preventing women from actually accessing those platforms or opportunities. So that, I think, is the greater issue with regards to that issue. And also, there was a case in Kenya around the 2/3 rule on women representation. I don't think that ended well. Maybe you can remind me. So that's also a form of gatekeeping. It wasn't enforced because there was no political will, correct? Yeah. So I'm sorry I don't have time to talk about that case specifically. We do have to wrap up. So, oh yes, just one more point.
I can't stop myself from speaking about sexual harassment. Yeah, I want to be practical about this. We are from various bar associations, from diverse backgrounds. How many of us, if we're working in law firms, have sexual harassment policies in our law firms? Let's raise up our hands. You see, this is how bad it is. How many of us are aware of if our law societies have adopted model sexual harassment policies? This is Zambia, that is Kenya, Nigeria.
Not Kenya, Palu.
I'll tell you. Lulu and Mr. Yandruga, we're from Tanzania. Our law society has a sexual harassment policy that was supported by the American Bar Association. And I'm certain that none of our lawyers knows anything about it. That's how bad it is. And we have to take this seriously. Because some of us, we speak to young girls who are, taking off in their legal professional career and they shut off immediately because of sexual harassment. We have to pull the bull by the horns, if I may use that word. We have to get out here with a statement that every bar association in Africa has to adopt a sexual harassment policy, and that has to be deliberately, as Lulu said and Chikondi, communicated in all cycles of our legal profession. Thank you.
Thank you. I will just end with my favorite story on why gender equity matters, why representation matters. And I heard it narrated on the radio, on the BBC, by the then Swedish Foreign Minister. And she told the story about two warring factions who were fighting over a river on a map. And everyone in the room was a man. And then they decided to introduce women to the conversation. And the woman pointed out that, in fact, the river they were fighting over had dried up many years ago, and they knew that because they fetched water and cared for the home. So that is just a clear illustration of the different perspective that women can offer that is not often at the table. Thank you very much, ladies and gentlemen, for your attention.
And thank you very much. I'm really sorry that we ended up starting a bit late and we lost time because the technology, even though it was tested last night, it failed us when we now started, so I apologize for that. Just to say, because I think the challenge was that we take this very seriously as PALU. There are actually 3 PALU vice presidents and the sector in general in the room, not just me. And the challenge that we've been given, I think we take seriously. Actually, in partnership with the Mal Clooney Foundation, we're bringing in, starting 15th July, a full-time project officer on women's rights and the law in Africa, because it was a sourcing thing that we didn't have before. And just to remind all participants that we are re-energizing our committees and our fora. And we do have a Women Lawyers Forum. And have a Women Lawyers Forum activity at every annual conference. Remember, Lulu, we were together. Thank you, Lulu. Thank you to the Legal Services Facility for supporting, for sponsoring this particular panel. So it's not to say that we're relegating as a panel leadership women's rights issues to the Women Lawyers Forum. We know it's a policy issue that the leadership should work on. But we're also encouraging members that rather than just discussing at the annual conferences, let's be active in the committees so we can work together throughout the year, and then we can now be showcasing our work at the next annual conference. So the Women Lawyers Forum is also open for you, and you can get more details on our website or through our newsletters. So please, let's kind of rush through tea so that the next sessions start on time, whichever of the 3 sessions you pick. Thank you.
Topic actually, and I'm very grateful to be joined by my panel today. The details are in the program, and in the interest of time I won't go into them, except to say that we've got Walia here, we've got Yvonne, Lillian and Leroy, all from very different walks of life in the legal field, in the international scene. And I'm going to hand over to them individually, just to say where they're from, and what about this topic really speaks to them, what made them get on planes, arrive here, and have something to say to our party audience. Without further ado, I'm going to hand over to Yvonne. And Yvonne, if you would just take between 10 and 15 minutes to give some insights from your experience into what our party audience can learn about this topic. Thanks very much.
Thank you, Linda, for that introduction. It gives me great pleasure to be here in Zambia and to be part of this conference. I am passionate about being an Pan-Africanist, and so I'd like to contribute any way I can to our development. So in terms of my background and where I come from, so I was born in the United Kingdom. I'm of Jamaican parentage, and I practiced in the UK as a solicitor. And I practiced in local government initially, then in private practice. I was then a partner in a small West End firm, and then I established my own practice and specialised. So that was the first half of my career. And then for the second half of my career, I worked in regulation. So I worked on the board of the Solicitors Regulation Authority, and I also undertook quasi-judicial work for the Nursing and Midwifery Council. I did investigative work for architects and worked with surveyors. So I bring my experiences as a practitioner, but also as a regulator. And what I want to talk about today is why thinking about practice management, how you practice your law and regulation is so important. And just an eye on the topic we have here, international practice. In the mid-1990s, being an African-Caribbean lawyer, I was aware that there were several lawyers coming from Africa to practice in the United Kingdom. And what concerned me was that many of my fellow lawyers, no sooner did they set up in business, that our regulator would be shutting them down. And that was for many different reasons. So I took it upon myself to challenge both from the outside and then effectively from the inside, because I was appointed to the board of the Solicitors Regulation Authority. And there were a number of issues that I became aware of. because in the UK, the Solicitors Regulation Authority were quite aggressive in their regulation of firms. And if you went and practiced without having full understanding and knowledge of, for example, the most important area, accounts, finances, I took it upon myself to attend a solicitor's disciplinary tribunal hearing to see what were the issues. And it was apparent to me that the lawyer before the tribunal really had no understanding of keeping her office funds totally separate from her client funds. Yes, it was a revelation. But there were people who came to the UK, established businesses, perhaps because in the jurisdiction from which they came, the requirements were not as strict or were not as clear-cut in terms of separating your client funds from your office funds. So that was one particular issue. And we found that there was a disproportionate number of firms and Caribbean firms, people with non-sounding English names being shut down. And the investigations were undertaken, and much of it, or some of it, was because of breaches of accounts rules. That was overwhelmingly the one that would shut the firm down. Breach of the account rules, mixing your money and your account's monies. But also, some of the areas in which they practiced, a lot of it was immigration, family, housing. The clientele, those areas seem to generate more types of complaints, and also the size of the firm. So many of the practitioners were either sole practitioners or in smaller firms. And so when a complaint came before the firm or the regulator, they didn't have the mechanisms to say, let that partner deal with it, let the HR firm deal with it. And so how you practice and where you practice can determine the number of complaints you receive and how they're dealt with. Because with a small firm, if you don't have the resources to resolve the issue with your client, they will go immediately to the regulator, where the sanctions and the outcomes are likely to be far more serious. In the larger firms, they will have their human resources department, they will have another partner, and they will have systems that can hopefully bring resolution to the client before it ends up before the regulator. So my point really is, and there are still, there are great opportunities, because England is a rich country, the United Kingdom is a rich country, you can make a living there as a lawyer, and people need services. People want people who understand their culture, their language, to act for them, but you have to understand the regulatory environment into which you're practicing. Service delivery. Often lawyers think that complaints will be about failing to understand the law or practice, but the vast number of complaints is about service delivery, failing to manage expectations, and failing to abide by the standards you set for yourself. So if, for example, you as a lawyer tell your prospective client that it will take you 2 weeks to prepare a land document or to secure probate, etc., ensure that that is what you do. And more often, many advocates, they give unrealistic timescales, and then that leads to complaints naturally from their client. So, moving on to the second area that really is important to me is not being isolated as a practitioner. I know that there are many advocates here from large firms, but there will be many sole practitioners and many in small practices. When I established my own firm way back in 1994, within a year or so, I set up an organisation called the Black Solicitors Network, and the purpose of that organisation was, one, to raise standards, two, as a support network, and three, to engage with the faculties, have no one to talk to. They cannot talk to their colleagues. And so they are at the mercy of the regulator. The organisation is still functioning today, and it has branches for firms that do lay work, city practitioners. So what I would say to lawyers who are seeking to do work in another jurisdiction is to make sure you ascertain what are the organisations on the ground. Join those organisations, do your research, and not only be a beneficiary but contribute. In the earlier session, we were being spoken to about the need to collaborate. I recall when I had my small practice, there was an organisation that gave contracts for me to do legal work. And there were threats to the smaller firms. And it wasn't quite clear as to why the threats were coming. And so those of us that were in those smaller firms engaged with the organisation to say, what are the challenges? Is it because we are too inefficient, or what it is? And when we could not get answers, we threatened legal action. And we as lawyers, because we know the territory, we can threaten legal action, which caused, it was the Legal Services Commission, and they gave out contracts to look again, to think again, and not to shut us down. So, being part of an organisation is so important because it prevents you from being isolated. It ensures that you know what's going on in the profession. It keeps you sharp because I think all of us want to be the best advocate that we can be. And by seeing how other advocates perform in different environments, it's not only a motivation for you, but an encouragement. So I don't know whether that covers it sufficiently. And I can answer any questions.
Yeah, I think for the interest of time, we'll just move through just to get all the different viewpoints, and then open it to the floor.
Lillian, you're up next. I know that you're going to talk about some education, which I think is pretty interesting. Over to you.
Thank you very much. My name is Lillian Effiong. I'm a lecturer of the Nigerian Law School. I'm Deputy Director, and I'm going to be talking to this topic from the angle of legal education. Now, as we all know, the foundation of legal practice is the legal education itself. So if we are talking of having lawyers who will do work globally and who will be able to practice in international law firms, it has to come from the training itself. How do we train them? So the training of lawyers should reflect what we want them to do in the future. That is being global lawyers and being international lawyers. Now I'm going to be talking about the curriculum itself. And I'm going to be referring a lot to the Nigerian Law School where I work. Now, the way we structure our curriculum in Africa, Nigerian Law School, Ghana School of Law, and even some other law schools in Africa, the curriculum is structured in such a way that we train the student to be able to function and work within our country system. We don't look at the opportunities that are available to them outside. Now, the fact is that right now, there are a lot of development in the international, at the international level, and lawyers must be trained to be able to function well. So we need to develop a kind of curriculum that, after training, the lawyers that we produce will be able to function effectively at the international scene. Now, taking Nigerian Law School as an example, we have professional ethics as one of the modules, and one of the topics in the professional ethics is the history of the legal profession in Nigeria. Now, the history of the legal profession in Nigeria, we trace the history of how the legal profession started in Nigeria, looking at those who may practice from 1861 to 1960, when Nigeria became independent. And part of what we teach, or what we tell the students, for you to qualify to practice under that period, there are certain things you have to know, then how to obtain your license, to be able to practice and all that. So I feel that is all we do about referring to international practice, as in it is in teaching of history of the legal profession. Now, I feel right now we should restructure our curriculum in such a way that we'll be able to include topics that will let the student know the requirement of practicing in certain jurisdictions apart from their immediate country. So I think that should be done. Also, we need to look at our curriculum and develop it in such a way that the students will have knowledge of how they practice procedure in other jurisdictions apart from their local jurisdiction. At the Nigerian Law School, we have another module, which is criminal litigation and civil litigation. Now, under criminal litigation, you are told about all the procedural laws, what you need to do in order to prosecute crime in Nigeria. So I feel the curriculum should be expanded to also include what you need to know in relation to criminal proceedings in other jurisdictions, particularly selected jurisdictions that we may feel that in the future our students may want to practice there. So generally, the law schools, the School of Laws in Africa, should expand their curriculum in such a way that students are made to have knowledge of what practice is in other jurisdictions. Also, another thing that can help is the issue of internship and externship. At the Nigerian Law School, part of the program is to send our students on externship for a period of 10 weeks. The first 6 weeks, they are sent to courts where they watch proceedings, they observe, and they are expected to acquire lawyering skills through that program. Then the last 4 weeks, they are attached to law firms within the country. They are attached to where law firms that are busy, where they could learn proceedings and other lawyering skills. Now, helping our students to be able to attach or work in international firms later in the future when they become lawyers, I think we can expand this program. Now, the law schools or School of Laws that do not have this particular program should help to have externship and internship programs. But like the case of Nigeria, we need to expand it to include a station where we send our students to other jurisdictions apart from our local or within the country, where they can go for externship for a period of time and understudy lawyers in these jurisdictions, go to courts in these jurisdictions with lawyers and learn how things are done. Now, at the end of their training, having gone through all that, they will be able to practice well and be able to integrate faster into foreign firms. Another aspect of what we are looking at is the issue of networking opportunities. Now, I'm looking at this strictly from the angle of legal education. So these networking opportunities I'm talking about has to do with law schools having programs in place that will help network with international law firms, whereby students can benefit from such programs. So eventually, when they have the opportunity to interact with the international law firms, even right there when they are still in the law school, by the time they graduate, they'll find it easier to be able to integrate and also function at the international law firm. Another point I have here is mentoring program. As students in Africa, law students in Africa should be exposed to mentoring programs, whereby the young students and even young lawyers can be attached to lawyers from other jurisdictions for the purpose of mentoring, where those lawyers will mentor them as they continue in the law school, and then after graduation, the lawyers in all these international law firms will continue to mentor them, and where the opportunity arises for them to be able to practice in these international law firms, it will be easier for them to do because of the previous mentoring. Another point I have here is the study abroad program, whereby students from various law schools across the continent can be sent to some of these jurisdictions. We hope they may be able to practice internationally later in the future. So they go there maybe for a period of 1 month, for a period of 1 year to study. But this we need a kind of arrangement with those institutions abroad. So they go there, they study for a period of 1 month, 1 year, or as the case may be, and learn firsthand the proceeding or the proceedings in those countries. Now, the difficulty we may have in this is who sponsor the students. I was thinking of that when I decided to include this point, but it is something that can be done. Because what we are talking about here, we need not just individual law schools having that will to do this, but also there will be need for institutional support from the government of the African countries in order to be able to achieve this. Another point I have is collaboration with international organizations, whereby law students, law schools, first and foremost, have a kind of relationship with international organizations like International Bar Association and some other relevant legal associations. And some of the students in the various law schools can be selected to attend some of the conferences, and in the process of attending the conferences, they can meet other lawyers from different jurisdictions and then have a kind of relationship with those lawyers that will be useful for them later in the future when they graduate and become lawyers. Another one is professional development and continuing legal education. So that even after graduating from the law school, there's need to continuously attend professional development and continuing legal education. In Nigeria, we have that. It is a requirement and it is provided for in our rules of professional conduct, whereby lawyers are expected within a year, even after you graduated and you're not practicing, within a year, you are expected to participate in professional continuing legal education by attending conferences, attending lectures that are organized in order to improve yourself. So this also is very important, and it will help lawyers to be able to integrate and also practice in international affairs by attending conferences organized not in their local jurisdiction or in their country, but international conferences, and also attending even courses where a lawyer can decide to go to school abroad just for a short time in order to develop him or herself. So these are the points that I've put together. Unfortunately, I have my DG here, the DG of the Nigerian Law School is here, and I'm sure whatever we decide, he is in a position to push for implementation. Thank you.
Thanks, Lillian. And I think when it comes to questions, I might have a couple of questions of my own in terms of the responsibility. You've made some very, very helpful suggestions. I just don't know who to hand the baton to in order to put the training, to put programs together. Who's funding it, who's arranging it? You need an entire secretariat in order to create this movement. I fully appreciate every single one of your points. I'll put it to you at the end, but if you could give it some thought, who can take the reins here and actually deliver on this? Because it's really an implementation question. I think every one of us here agrees with you in principle, but delivery is the proof is in the pudding. Anyway, without further ado, let me hand you over to Leroy Wilson. Leroy is furiously making some notes here. Perhaps you'll answer my questions. Let's have a look. Let's see what experience says on this topic.
Thank you very much, Glenda. My name is Leroy Wilson, Jr. I was born and raised in the state of Georgia in the United States. I started practicing law in 1967. So it's very amusing to me to hear somebody talk about a long time ago in 1997. So in essence, I've been practicing for about 56 years now. And I started my legal career at IBM, International Business Machines. And I've also worked in the law department at Union Carbide Corporation. And apart from that, I've been in private practice since about 1982, and there was a short period in the 1970s. I think what I'd like to do is to make some comments with respect to non-South African countries, and then to make some comments that are specific to South Africa. And of course, the comments that I make with respect to one might also be considered to be applicable to the other. I think I should say, as lawyers do, that these are my personal views. They're not necessarily the views of the National Bar Association or anybody else. I think sorry. Thank you. My experience in international affairs really started in 1959 when I was a student at the University of Vienna in Austria. And so I developed a very intense interest in international affairs. And in the 1950s, we had the anti-apartheid movement arising in the United States, and I became interested in the events that were taking place in South Africa. Now, let me fast forward to say that I think the most critical thing that one can do in trying to develop international practice is to establish personal relationships. And what I'm going to talk about in just a few minutes is what has happened as a result of personal relationships that I had. In 1973, I received an invitation to attend the World Peace Through Law Conference in Abidjan, Cote d'Ivoire. So the question is, how am I going to afford that? Well, I had a friend in Atlanta who told me that a friend of ours, a mutual friend, had told him that Dean Rusk, the former Secretary of State of the United States, wanted to try to interest black lawyers in going into foreign service and becoming interested in international affairs. So one thing led to another, and through that chain of connections, I was able to set into motion a process which I think enabled about 200 lawyers to travel to the Ivory Coast. So that was my first experience with international affairs per se. Now in 1977, Gardner Nysa became a neighbor of mine in Mount Vernon, New York. And 1977, we met for about every day for a year, upstairs, downstairs, talking about all kinds of things. And then in 1979, after the Union had been overthrown, and the president at that time, Maputo Protocol, resigned, they needed somebody else to serve as president, and Gandhi was selected. At a point, I was working with him on 29 different projects, and if we get a chance, I'll talk about a couple of them. But I think I will mention one that demonstrates how certain connections ought to be at work. In this question of the power equation, who has the power to do what in these negotiations that we've been hearing today, I contend that there's a greater interest and need for financiers and Western companies to have resources for African countries than African countries have the need to raise funds to support certain kinds of projects. Now, the reason I say that is because boxers, prize fighters, were getting shortchanged until Don King came along. Don King recognized the value in Muhammad Ali, and he knew that he had the asset to beat the need. Now, with respect to moving towards a green economy, there is an overwhelming demand for certain resources in Africa. And so from that standpoint, I think I would invite people to examine the power equation and see who really has the power in these negotiations, who has the greatest needs. And I believe that people that need the resources do because they need all of these various minerals to go into these cars and so forth. Now, the example that I want to cite is there was an American businessman who went to Uganda who wanted to supply Uganda with trucks in order to move coffee from the coffee fields to the coffee marketing board. At that time, the roads weren't very well in the special kinds of trucks. This businessman from New York went in to see Godfrey. I call him Godfrey with no disrespect because I know him as a friend before I knew his president and attorney general. So Godfrey asked the man, do you know Leroy Wilson Jr. who lives in New York? I said, no, I never heard of this guy. Who is he? He said, well, I tell you what, you want to do a deal with me in Uganda, go back to New York, talk to him, I'll talk to him, and we'll see what we can do. Well, that particular deal did not come through because of various political reasons. But I suggest that that forms somewhat of a model in terms of what sovereign nations can do. Recently, any number of presidents have been pushing this notion that we are sovereign and you can't tell us what to do. Well, if you're going to be sovereign, my humble request is that you listen to your local lawyers and empower them. And if somebody wants to come into your country and do something, ask them which local lawyers they have communicated with. Then empower those lawyers to hire lawyers on the outside if need them. And not the other way around. Because one of our panelists pointed out, well, they hire these outside law firms, and what happens? The outside law firms in the U.S. come to the local attorneys to hire them. So let's reverse that process. I don't care if the local lawyers don't know anything about it. Whatever it is the person wants to do. Read the biography of the law firm of Skadden Arps, S-K-A-D-D-E-N, in New York, which is about the 5th largest grossing per partner law firm in the world. When they had their first really significant meetings, the lawyers in Skadden Arps met with the business people. They had no idea what they were talking about. So they rushed out after the meeting, went into the library, did the research, and came up with an approach to solve that particular problem. So we can talk more about that a little later. Mentoring. I also believe that's an extremely important process. And I want to give you one example of how some of these mentoring programs can work in actual practice. When Godfrey became the Attorney General of Uganda, there was going to be a changeover, and now people call this by certain terms. In some cases, it's called indigenization. In other cases, I've seen a new term yesterday. It's called local content. And what happens is that, to use one of Lyndon's terms, it amounts to passing the baton. When Uganda became independent, the structure of the Attorney General's office was white. There was a white male who was the Attorney General of Uganda. They developed a program where Godfrey would become Attorney General, and Godfrey needed a Solicitor General. So he went down, he sent a letter in English to a solicitor, to a man in Tanzania who was a lecturer, Mr. James Mugerawa, whom I also met, and asked him to come and be a Solicitor General. Mugerawa ignored him. So then he wrote a letter in Uganda, and then Mugerawa felt compelled to respond, which he did. And so Mugerawa said, well, listen, Godfrey, I don't know anything about trying cases. Godfrey was a barrister. He was a Queen's Counsel. I think he might have been the first black Queen's Counsel in Sub-Saharan Africa. I'm not sure about that, but I think that's the case. He was also admitted to practice in New York, and I moved to the mission practice there. But, so he said, well, listen, what we'll do is this. I will tutor you. I will mentor you. We'll go to court. I'll try cases. I'll examine this witness. And I'll prepare you to examine the next witness, and that's the way we will go. That is the way that particular relationship develops. And I suggest that's the same thing that should apply more in South Africa, which I'll talk about in just a minute. But we have the same kind of issue in New York with respect to attorneys, black attorneys in particular, not being mentored by white superiors in those firms. The statistics are there. I did submit a number of articles, which should be in your reference material at some point, so that you see what's happening there as well as here. But again, remember the power equation I talked about. Let me say a few words about South Africa. I first became very much interested in South Africa when I read about the plight of Nelson Mandela and his political prisoners under apartheid. By the way, I should tell you that a couple of months ago, I was part of a group that launched the American Voices Against Apartheid, so that South Africans would understand some of the things that African Americans in particular did in order to get rid of apartheid. I hope that we would have a tape here so that I can flip these pages without. The reason that I prepared this presentation this way is to talk to those lawyers who are not necessarily corporate lawyers. When I talk to every other person here, I say, well, what kind of practice do you do? What area of practice do you do? They're all corporate lawyers at one time or another. Statistically, I don't believe that, I must tell you. So I'm talking about what can happen in terms of personal relationships with respect to individuals. Okay, how long time?
5 more minutes.
Okay. When the bombing took place in Kenya, I think in 1998, and Tanzania, the Kenyan Law Society circulated a memorandum around the world asking for assistance. One of those memoranda hit the National Bar Association and came to the International Law section, of which Barbara Simmons is now the vice chairman of, asking what do we think about certain things. I got involved in that and actually started talking with someone in the State Department in the United States because I knew that first there was a great need for some immediate assistance in Kenya and Tanzania. Secondly, our fiscal year in the U.S. was about to end. And so I wanted to see if, number one, some emergency funds could be made available immediately, and number two, could there be improvement in budget item for next year, something to help these people. And then I'm happy to tell anybody about how that particular effort was sabotaged and how the person who sabotaged it later, apologized to me profusely, but I'm not going to go into that right now. Now, going back to this issue of sovereignty and what sovereigns can do. Botswana, which is where I now live, as you know, has the world's first or second largest production of diamonds by volume, I believe, in the world. And so they had a joint venture with De Beers in a corporate that was called Botswana. That agreement is coming to an end and needs to be renegotiated. And so President Masisi took the position that these are our diamonds. And you're going to have to deal with us in terms of what we need to get out of this relationship. And as a result, a couple of days ago, that relationship was renegotiated and President Masisi got what he wanted. That is the way sovereign nations have to begin to act. And some are beginning to do that. You've got President of Ghana, you've got President Kagame of Rwanda, you've got President Maputo lately. You also have the Prime Minister of Barbados, and several other presidents have taken strong positions in speaking back to power, truth to power. You have President Gingab of Namibia as well, asserting Namibia's interests when the German ambassador asked him how many Chinese he had, were there in Namibia. And he told us none of his business. Now, this unusual kind of thing taking place right now. Now, with respect to the sovereignty issue, I noticed that there was a huge contingent here from the DRC. And maybe somebody can explain this to me. When Apple decided to pull out of China, Africa, I believe, I think that Apple then relocated those facilities into India. So the question is, what did the DRC say about that? Apple cannot survive, I don't think, without the minerals, coltan, and cobalt in the DRC. But I didn't hear a word from their president, and I hope you'll forgive me for saying this. But I'm just pointing this out as an example where I think that the DRC could have been in a position to say, well, look, you're going to get our minerals, you got to locate those facilities here. But that didn't happen. And as you know, on a retail basis, Apple is the largest corporation in the world in terms of US dollars. And so some of those dollars need to be earned and shared in the DRC. South Africa. Just a couple of things, and I have submitted as I think I said earlier, a number of papers and resource material which I understand will be available, that you can have a further reference to some of this material that I'm talking about. I want to talk about just a couple of things with respect to South Africa. Number one, and I know this because of my engagement with attorneys in South Africa, and that is that in these large law firms, I remember going back to New York one time, picked up a newspaper, and there was nothing but black people and people of color advertised for this particular law firm. So I called my friend. I said, listen, this is what I saw, blah, blah, blah. How are these black people in New York and people of color getting in these firms? He said, well, look, they're there. But what happens is when the firm goes to a client to make a presentation, they'll allow the black lawyers to make the presentation, but when they come back to the office, they don't let them work on a particular project. So that's something that needs to be addressed. Number two, the Minister of Justice and the Minister of Justice in South Africa is the largest buyer of legal services in South Africa. But they're managing not to instruct black attorneys in South Africa. That's something that the attorneys there are trying to address. There needs to be some external pressure on it. It's a disgrace. You know, people in the U.S., where I'm from, did not participate in anti-apartheid movement or push the Afrikaners out and the nationalists out so that the status quo would be maintained after apartheid was defeated. So that's something that they need to address, and I know that they're trying. Now,
We can give you a little bit more.
Oh, okay, very quickly. Class actions. If you don't know what they're about, find out. And I want to suggest also that the National Bar Association's annual meeting is in about a week or so. So that will give you time to network with the Native lawyers in the States. Richard Spoor, in case you haven't heard that name, is a man who was a white South African who was representing black people in the class action and silicosis cases. Those cases yielded settlements of hundreds of millions of dollars. On a given occasion, a person of color, a young Indian woman, asked him why weren't there any black lawyers on his team. There were 42 lawyers in the court. And what he said to her was, we can't hire any black lawyers because you have to be almost a genius in order to class action lawsuits. That's what he said. And included in my package is an article on the protest that the black lawyers made in court and filed a petition with the court to protest against what Spoor did. Now, having said that about black lawyers, what does Spoor do? When he wanted to prosecute the class action lawsuits, he went to the United States and got a firm out of South Carolina to come in there and tell him how to do it. So that kind of hypocrisy just cannot continue to stand. Last thing, and the other one, but the last thing is this. I looked at some of the law. I was in South Africa about maybe 2 months ago. We were driving down the road. I look up and I see Baker and McKenzie, a huge building in Johannesburg. I'm saying to myself, what is this? There's no stability whatsoever. Well, I looked at the makeup of the partners in that firm. In Johannesburg, not a single one is black. There are people of color, but there's not a black person there. That's a disgrace. And I looked up a couple of others and it was the same story. So that all of that has to change, folks, in my opinion. I'll shut up.
Thanks, Leroy. Just to sort of wind up, or tie up how this panel has come together, we've obviously spoken to Yvonne about practicing overseas and some of the challenges there. Lillian weighed in on how to sort of get your grounding right in order to be a springboard to getting overseas or perhaps in another jurisdiction. Leroy on personal relationships, I think that came out strong. But Walia, my colleague on the far right here, is really quite an embodiment for me of where a lot of African law firms are going very practically and realistically in their own countries. And Walia represents a law firm called Bowman's, which I'm sure many of you will know, which was historically a large South African law firm, who have invested in their African footprint on an integrated fashion, whereby they share fees, share kitty across the continent with branded law firms. You are one firm for all intents and purposes. And it's an interesting model on the continent, one to compare with best friend networks or group firms like the DLA Piper. And well, I'm very interested to see what the point of reference is from you on how this model is working, how you're best serving your clients and best growing your career personally. We welcome some comments from you.
Okay. Thank you, Glenda, and hello, everyone. As Glenda has mentioned, my name is Wadia Sonda, and I'm a partner in BNN Legal Practitioners. It's a law firm in Lusaka, Zambia. That's a member. It's a law firm that is a member of Bowman's, and as Glenda has mentioned, it is a Pan-African firm with offices in 5 different countries. And the idea is for us to network and share a lot of services. And we have a lot of access to each other's services as a result. But what I want to talk about is international practice and practicing law on the international scene, and what strategies should be employed in order to be able to practice on this platform. And the reason why it's important, or at least in my view, it's important, is that so the reason why it's important is because international law firms or international clients are able to pay premium fees for services. So in order to increase our profitability as law firms, this is a market we want to tap into. So it obviously, I think, follows that you want to build a strong professional network that will be able to tap into this market. But I think what's key for me is, what do the clients want? If you're an international client, if you're an international law firm, when you're looking to work with a local partner, what do you want to see? What will encourage you to be able to work with them? And when you focus on the client, it sort of allows the firm to grow and to make the various changes that will then be able to play on this scene. So, in my view, international law firms, international clients, they want a skilled and knowledgeable lawyer. So this is something that Lillian has spoken to. The legal education and the background that you go through. What we have seen also is there is an interest by clients in hiring specialized lawyers. Being a generalist is sort of not the thing anymore. You want to be a tech lawyer, you want to be a competition lawyer, or a mining lawyer, for example. So you have expertise in different areas of law that you tell clients that this is an area that you're able to assist in. Clients also want to be able to manage their legal fees. So in as much as the international market is profitable for local law firms, they still want to be able to manage their fees, which means that you need to have systems in place related to time and billing that will allow you to have transparency around your invoices and your billing. Sometimes we have clients who complain and say they didn't use a certain law firm because they had a block figure of $10,000 for services rendered. And they're wondering, how was that broken down? Is that how much I actually accrued? So that's something that we see is quite important. Another issue is, how do you manage your documents? How do you maintain confidentiality? If you're going to tell a client that we're going to establish a Chinese wall in a law firm to do work on a deal, how are you implementing that? Are you restricting access by some lawyers to certain information versus others? Do you have the systems to be able to do that? Also, what has become very, I think, key for clients also is, are you embracing technology? You need to, I think COVID was a blessing in disguise because it allowed us to speed up in our processes of embracing technology. Being able to have meetings, not in person. So you need to have systems that allow you to do that. Some law firms, lucky for us, we were just starting in the pandemic, which meant that when we started, we had to buy laptops for everybody, as opposed to buying desktops. And that sort of helped and propelled our being able to practice in a pandemic. The other thing that's becoming key, and what we're hearing clients talk about, is diversity and transformation in the law firms. They want to see, female partners. They want to see female juniors. They want to see juniors in general on matters. The idea of going for a client meeting on your own is not impressive to the client. They want to know that you have a system that backs you up, that you have people that do the underlying work that you can finally sign off on. So, marketing yourself as a sole practitioner and practicing alone is not something that tends to be attractive to international law firms and international clients. Which also goes down to talent, and I think Lillian has also talked about this, right? We need to invest a lot, and that's something that we do. And being part of a woman's talent? Are we hiring the best people in Zambia to be able to do the work for the clients? And we see that this is an ongoing question. Who has joined your team? Who has left your team? Etc. So it's something that you constantly have to build. So that's also important. Earlier we're talking about women and their participation. That's also important to have in place. So things like having a sexual harassment policy. I want you to have those policies that are intended to promote the growth of a law firm. Then, another thing that I've seen that is key and that we have to do as well, and it's easier to do when you're also in a network, is value-added services for clients. You know, it's not just that you have to do the work or you have to sign the letter of engagement. They want to know what benefit do they get from having you as their lawyers. So are you giving them legal updates? Are you training them? Are you giving them secondments, for example? So those become very key in terms of how you deliver to your international clients and to the international market. Now, I'm just going to delve into, so we know that this is what clients want to see. But what are the formal strategies that you can personally do to be able to engage with the international law firms? And, you know, attend conferences like PALU, for example. I mean, this is a great opportunity to network, to meet people. So networking is very key, whether it's at the IPA, the SADC Lawyers Conference, and other platforms. Because you obviously, at this point, need to build your brand and to build that reputation. So it's important to then interact with these, whether it's international firms, international clients, in the various platforms that they exist and where they meet. Then, take advantage of the legal directories. The legal directories, allow you to be listed, and they give you that credibility that someone has done their homework based on some research, and you're ranked. But it's extremely important. It's amazing how many referrals or how many clients you will get because they read, a Chambers review, or they read a Legal 500 review, or IFLR 1000. Those are very important directories to get into. And in as much as it can be frustrating, and I'll speak from personal experience, to get into these directories, it's certainly worthwhile in the end. Then the third one that I wanted to talk about is, get into alliances. Someone said to me, they said it simply and said, you need to make friends. And that's what alliances are really about. You are the professional, you are the expert in your local field. But you need to make friends of international law firms, of other alliances. And it's an ongoing process. I think a few weeks ago, we were hearing how Shearman and Sterling was merging with Allen and Overy. It made me realize that these are two big firms that you would never think would want to come together. But for whatever reason, they have decided that they want to align and they want to come together. And it sort of reminds you that, two will almost always be better than one. So create those alliances, create those networks. Even for us in Bowman's, we also have our alliances in order to be able to further our reach beyond Africa, beyond, in my case, Zambia, to many more countries. So certainly make those friendships, make those alliances. And then I think just to comment on maybe what Leroy had mentioned and that we had talked about, is that as law firms in Africa, we also have the opportunity to take work to the international law firms. And that also increases our ability to participate in the legal fees. And that's why we're saying, government should make conscious efforts to ensure that local lawyers are instructed on matters, so that you're the one who's getting in touch with Clifford Chance to say, look, there's an English law aspect to this instruction we're working on. What are your fees? Get in touch with us. That allows us to also play on that international scene. So that would be my greatest plea coming out of this, and I think we'll carry this on with our law society as well.
Well, yeah,
Thank you.
Thank you for that. I just would love it to come from you. In terms of your firm, what we haven't quite touched on, and it's basic, is what are the building blocks of getting your firm noticed? So you've used, please, in my... It's not going to... No, it's fine. Well, it's not so much a question as I'm just prompting you to say what's happened in your firm. For a number of the individuals here that are either sole practitioners or part of one or two man law firms, just the very basic building blocks of putting your firm out there on the international scene. Perhaps you could just give a small checklist. Everything from making sure you've got your website that says exactly what you do, that you list your people, have contact details, business cards, LinkedIn, thought leaderships, alerts, a pitch, your fees. Look, I'm actually saying it for you. Yeah. I'm answering my own question. You know, these are, you can't take for granted what international firms will judge you by. And if they go onto your website and they see the Gmail address, that's a red flag for security. If you don't say you do all the services, so you're busy putting yourself out there as a telcos lawyer, and they go onto your website and they see corporate, commercial, real estate, IP, and then they say, well, you know, where is the right specialization? Or if they say send us a firm profile, and it's, you know, very outdated document, you will get judged by that. And I would love to understand your experience on how aligning with Bowman's has given you the opportunity to sort of leapfrog some of those just entry-level barriers by having professional support, and how you feel that that has gone a long way to expand, widen your profile, your PR, and how people have found you and how people find you credible because of it.
Well, so being part of the Bowman's network has definitely helped. And I think, Glenda, to your point, what we're talking about here is business development in general. This is something that, you know, it takes a lot of effort and a lot of time. But of course, when you're part of a network, you're able to ride on the business development efforts of others. And in our case, for example, we have our own business development manager who sits in Lusaka, Zambia, because of how important we see business development. But this is something that every law firm must think about, which is how you're presented to the world. So like she mentioned, you know, email addresses, your websites, how are you presented? To be fair, in a country like this one, Glenda, you don't have to be a tech lawyer or a mining lawyer. I think we're at a point where it's okay to be a corporate lawyer and sort of do everything within the corporate world. But obviously with time, this is going to become necessary to specialize. But those are some of the efforts that you have to put in. Like I mentioned, value-added services. Clients want to know that you're going to be updating them about the law as it changes, and at no cost. But you use that as a business development opportunity. You know, use platforms like LinkedIn, you know, actively to show the world what you already know. And alliances tend to help with this because, you know, you will have certain joint BD efforts, but ultimately, it also sort of starts with you as well, to be able to make some of these efforts on our own.
Yeah. I think it's time to look to the floor for a couple of questions. We'll start over there. If you could just introduce yourself and a short question. And if you have anyone you'd like to address it to, please feel free. Alternatively, we'll share it amongst the panel.
My name is Alphonse from Tanzania. I really like this discussion about building international practice. Yeah, I love the discussion about, I like the discussion about building international practice and building alliances. My name is Alphonse from Tanzania. So, Asante. 10 years ago, I attended a conference that was South Players Association, and we had an interesting presentation from our South African colleagues. They shared their views about the legal fees and within the African continent, and how much is retained within the African continent, I mean African lawyers. If I recall well, more than 70% of the legal fees earned in Africa goes out of Africa. They were talking of the big law firms from the UK, from Canada, from US, from Australia. And they pushed for an agenda that Africa has to build its own alliances, its own networks, its own view of international legal practice. And 10 years down the road, we have seen, my sister here, we have seen the impact that South Africa has brought within the continent. We have seen how governance has spread out through the Southern African region. We have seen how ALN, Africa Legal Network, we have ENS, we have Let's Africa. They're doing quite well. They came to challenge in my country. In the past, we were talking of DLA Piper, we were talking about Claudia Cole, Lotto Ross, Baker McKinsey, White case, Dentons. But now, we see Tanzanian firms building alliances with other African law firms, and of course, most of the alliances are from Kenya and South Africa. But I think this is the thing that we should look from the Pan-African point of view, that we should build our own alliances and retain legal fees and our continent within Africa.
Yeah. Over to you. You're next.
Thank you very much. My name is Isa. I'm from Nigeria. Mine is
Bwaya. Moments. Question for Bwaya.
yes. Very good. I'll sit down. So, yes, okay. My name is Isa. I'm from Nigeria. My questions are to our last presenter. If I had you right, in your own collective practice, you have other colleagues from other jurisdictions here. So is it as simple as working for across Zambezi to go and organize, establish a law office? Is that as simple as that? There are no immigration rules, rules pertaining who can practice here. Other qualifications. Can you enlighten us on this?
So yes, so we do have rules. So we have the Legal Practitioners Act in Zambia, which is also supported by the Legal Practitioners Rules, right? So the starting point is, obviously, I think even to Lillian's point, you've graduated from university, and then you go to our Zambia Institute of Advanced Legal Education, where you are admitted to the Zambian bar. Once you are admitted to the Zambian bar, you are required to practice, and you can open a firm once you have 5 years of experience in whatever field that you're in. So anytime so we are a law firm, it's B&M Legal Practitioners, and it's an independent law firm because we have to comply with the Zambian laws, right? Which means that in our network, we cannot allow other lawyers from other jurisdictions to come and practice in Zambia. So your alliances or your networks, to the extent that you do embark on them, they are actually helpful in the sense that for as long as you have an alliance partner in that particular jurisdiction, you should not, if you're a South African lawyer, participate in that jurisdiction. First of all, in most cases, I think in Africa, it tends to be, it's illegal for anyone to just practice law anyhow. So you become the sole, the sole person dealing with any, in my case here, it's Zambian law issues in Zambia. So what you will have is, so when it comes to the cross-border work, if an international law firm is representing a client that's doing something in Zambia, they might know a South African lawyer because that's who they work with. They'll ask that South African lawyer to say, we want to do something in Zambia, are you able to give us a referral? And because I'm in that alliance and in that network, they'll say, of course I'll give you the referral. I know Wale, and Wale can do what you're talking about because we've also been networking, we've been talking, and they know what we can do. So that client then brings their work to Zambia and you're able to advise on it. Of course, it's probably not as easy as I'm putting it out to you because it can be quite complicated depending on the various subject matter, the transactions, the nature of the clients involved, the nature of the international law firms as well. But generally, that's what you want to do. You can only advise within your jurisdiction. We're not saying you should try to practice in another jurisdiction. Because again, when it comes to alliances, remember, you're friends. So you don't want to step on your friend's toes by saying, I'm going to practice DRC law whilst I'm sitting in Zambia. Then there's no friendship. I must be able to say, I know a DRC law. Let me refer you to them.
Well, can I just jump in there? Can I just answer? I'll come straight back to you. I worked for ALN for several years, so the largest alliance of African law firms who don't have a South African member anymore. And they've collaborated extremely successfully without a South African support base. And ALN's magic and what's made them successful was partnering with like-minded firms in similar stages and evolutions of the firm's maturity, and having what they called a gold standard, so a level of a minimum requirement in terms of quality. Because when you align yourselves in a branded alliance or network, it can give you a halo effect, so your firm can benefit on the strength and the branding of the other firms, or it will take one instruction in one country for there to be a poor result, a poor service, and for the entire network to be brought down. So ALN do regular audits of the firms to make sure that correspondence is replied to within 24 to 48 hours, that fees are reasonable and checked, that you are continuing your legal education, your expertise, you're constantly developing, you're sending out client alerts, you are going to all the conferences, and it's that strength in the collaboration and the trust that these firms place in each other, which has really singled them out as one of the most successful all-African law firms on the continent. I think that might actually answer your question as well. And I think the invitation to everyone
in this room today is to create your own alliances. There's only a finite amount of them at the moment, and for the most part, these alliances do practice on an exclusivity basis. One country, one firm, and they support each other like that. So there's certainly not enough of them to go around. If I were to say, join Terraleaks, Interleaks, WSG, WLG, the global ones or the African ones. Depending on what's a good fit for your firm in terms of budget, if you're prepared to put your hand in your pocket and join, if you just want to collaborate on a slightly more ad hoc basis. But I think the name of the game is definitely to collaborate. And it's on everyone here today. If you've got that belief and you've got the time and you really feel passionate about it, take the business cards of people, get them all on a call and see what you can do. Because corporations are looking for a one-stop shop. They want to phone you in Algeria and say, I'm going to telcos deals across 8 countries. I just want to deal with you. Is there a way of me speaking to you in your time zone, in your currency, with your project management basis? Can you do this for me? And you need to be able to act quickly and trust those that are within your network. And if possible, have an understanding of their fees, have an understanding of their expertise, be able to phone them up and say, we need to move faster on this. Really have a conversation as if you were in a firm. And only then, I think, are you going to really get the attention of the international firms, who are a huge source of revenue on the continent. Although they are a middleman, I would love to eliminate them in many respects, so that a multinational doesn't have to go to DNA to find someone in Zambia. They can just go straight down. But that's work in progress.
And Glenda, just to mention that you can, even for moments, for example, in as much as, yes, you know, we are only in 5 countries in the whole Africa. So that I see it as you can make friends even though they have existing alliances. And the other reason is because sometimes we're conflicted, right? So if my Bowman's partner from Tanzania passes a client on to me, and then I say I'm conflicted to do this work in Zambia, who gets that work? So there's always, you know, a preferred firm. And you don't necessarily have to be, so you could be a partner, you could be an alliance partner, you could also be a best friend or a preferred firm. So it's really worth you still interacting with a lot of these, even the handfuls of alliances, because they also need a second, third, and fourth preferred firm.
We have a question over here, behind you.
Thank you. Thank you, Chair. And thank you all of you, the panelists, for important insightful information. I just want to pose, my name is Theodros, I'm the President of the Ethiopian Federal Bar. I want to pose one doubt and one question, actually. You guys were using the term appropriately international law firms. Is there any such thing conceptually, in strict senses, international law firm? Well, we can talk about cross-borders if it's operating in 2 countries. We are saying it's international, whatever. But is there, in strict sense, is there a concept called international law firms? And if we agree there is, what should the African lawyers and law firms should do in order to be considered as international law firms? So this is one doubt that I want us to discuss. And the other one is, if I'm getting clear, the other one is, what should be the role of the national bar associations to promote the law firms and the lawyers to the level that we are envisioning? So what should be the specific role of the national bars? Actually, this will be enough not to take more time. Thank you.
Okay, I'll bank that question. Gentleman with the glasses.
Non, je vais poser une question.
question est de savoir...
Je n'ai pas l'air.
Je peux?
Allez.
Merci. C'était juste concernant la création des alliances. Je voulais, s'il y a une possibilité, je m'excuse, je vais me présenter.
Sorry, I'm not hearing any translation.
One. Yeah. Yeah.
Yes.
Yes.
Ok, je me présente, je suis Maître Philippe Kimia-Kombo, je suis avocat en RDC. Alors, je voulais juste, si c'était possible, vous, Madame la Présidente, ou encore les autres panélistes, revenir sur l'énumération des fondations de base ou la création de ces alliances dont nous sommes en train de débattre ou de parler tout à l'heure. Cette création des alliances, quelles sont les fondations de base que vous pouviez nous énumérer afin que cela puisse clarifier le module dans lequel, ou la thématique que vous avez développée. Ça nous aiderait à essayer de comprendre le fond de la question. Merci.
Sorry, I managed to get the question. Won't you please repeat the question, just the beginning part for my panelists?
La question est la suivante. Vous avez parlé de la création des alliances. Dans cette création des alliances, pouvez-vous nous donner en exemple les différentes fondations de base qu'on peut utiliser pour mettre en place ces firmes? Parce que vous avez parlé de la création des alliances. Comment créer ces alliances? Vous n'avez pas, dans la manière dont vous avez développé, énuméré la façon à procéder dans cette création des alliances. Si on peut revenir là-dessus, ça sera quelque chose d'intéressant. Merci. Je ne sais pas si j'ai été clair.
Oui. Oui. I got it. Right. The gentleman right at the back.
Okay. C'est moi. Okay. That's your name, I guess. C'est moi ou c'est lui derrière? Was it me or the one behind?
No, it's you.
Me, moi.
Yes.
Okay.
Our French. Le francophone.
Le francophone. Bon. Ok. En fait, je voudrais rebondir sur. Bon, je vais me présenter. C'est Maître Jean Bronzé. Je suis membre du Patriarchal en République démocratique du Congo. En fait, je voudrais rebondir sur l'intervention de. J'ai oublié le nom, de Dar es Salaam de Tanzanie. En fait, il y a 9 ans, nous étions, je crois, au Swaziland, mais je me rends compte que le débat est resté au même endroit. 9-10 ans, nous avons débattu sur la question des alliances avec les firmes internationales, la fuite des capitaux, les Africains qui recevaient les dettes qui tombaient des tables alors que les firmes internationales se partageaient de gros morceaux. Mais ça me déçoit parce que 9 à 10 ans après, nous sommes toujours en train de tourner autour du pot. Est-ce que nous pouvons réfléchir sur des mécanismes pratiques? Je sais, peut-être que je vais décevoir plusieurs d'entre vous ici. Pour ceux qui viennent de la République démocratique du Congo, nous savons que la loi qui réglemente l'exercice de la profession d'avocat date de l'année 79. Et depuis cette année-là, la loi n'a pas subi de mise à jour. Et donc aujourd'hui, vous verrez que la plupart des avocats qui œuvrent au sein de la République démocratique du Congo, pour certains, n'ont même pas de site internet. C'est tel@gmail.com, yahoo.com, tout simplement parce que la loi n'a pas évolué et la publicité est interdite. Vous n'avez pas à faire votre propre publicité et ce sont vos barreaux qui doivent la faire à votre place. Pour ceux qui, entre guillemets, un peu comme nous, qui sommes un peu têtus, on fait des sites internet, on fait des présentations sur LinkedIn, c'est pas toujours évident parce que quand il y a des problèmes, on sait vous interpeller. Par moment, vous avez un site internet dont vous faites la publicité à l'étranger, pas à l'intérieur. Et tout ça appelle une certaine intervention, comme on se retrouve dans le cadre de Palou. Y a-t-il des mécanismes pratiques pour faire un plaidoyer au niveau des autorités, entre guillemets, de la RDC, afin que certaines choses puissent évoluer et qu'en interne, les avocats qui pratiquent puissent accéder au même marché, parce que soit dit entre nous, vous n'êtes pas connus, on ne vous consulte pas. Vous ne vous présentez pas, on ne vous consulte pas, et vous prendrez ce qui tombe de la table. Est-ce qu'au niveau de Palou, peut-on mener un plaidoyer pour qu'au niveau de la RDC, que les avocats soient autorisés à passer à la publicité? Parce qu'ici on le voit, les avocats en Zambie, en Afrique du Sud, au Zimbabwe, en Tanzanie, ils font des publicités, ils font des annonces sur Internet, sur les chaînes de télévision, sur les réseaux sociaux. Est-ce qu'il y a moyen de faire un plaidoyer pour que en RDC ça se passe? C'est vrai, comme l'a si bien dit l'un des panélistes, la RDC devait avoir la posture de dire partez, nous restons. Les avocats ne vont pas dire partez, parce que quand les firmes internationales viennent pour les mines, pour le pétrole, par moment nous pensons que, oh, je suis trop long, je vais être bref. Par moment nous pensons que les investisseurs ou les bailleurs de fonds viennent entre guillemets seuls, mais c'est des gens qui viennent avec leur directeur juridique et on vient avec des textes préétablis, ce qui fait que les avocats ne se retrouvent qu'avec des miettes qui tombent de la table. Merci.
Right, I think it's time to... Okay, we'll take one more question at the back before we round up with a few answers. The very back.
Thank you, Chair. I have a comment and potentially a response to some of the questions. My name is David Sigano. I work for the East African Law Society. I lead the organization. Maybe I just start from the immediate speaker, the immediate last speaker. He mentioned something on advertising. It's illegal in most East African countries to expressly advertise legal services on TV or on newspapers. And this is by law, it's not by other means. The law says you cannot expressly advert on TV and say I'm the best legal practitioner in the country. And so I don't know what happens in the GRC. Maybe the movement within the law association, they can push for that if they would want to advertise their services. But then, responding to this other aspect of the question, I have been in the Law Association, the East African Law Society, for the past 7 years. And what we have seen is, though the progress is slow, there is a lot of movement towards Pan-African firms that have cross-border networks, or firms that have practices beyond their own borders. In fact, over the past 6 years, networks like the Africa Legal Network have established more than potentially 6 offices in other countries. Partnerships that have been built by African law firms have emerged, led by Nigerian firms, led by Kenyan firms, led by South African firms. People have been going out to meet other partners from outside their borders and establish networks. There's relatively good growth, but it's not sufficient. And I guess that is the theme within this room, that the rate at which we are building cross-border networks is not enough. So this is a challenge to all of us in this room, that we can't do more. We can't build more networks. We were in Kinshasa not very long ago, and what we saw was farms in the country are still, like he says, inward looking. No one has yet opened up to what is there outside of the borders of the DRC, for example. And this is a part that we must move away from, because other people are looking to come up, and I like what Leroy said. Other farms, the Baker Mackenzies, are looking to come up and take up the cake that is already here. So if we do not expand ourselves, then it will be very hard for us to prevent or protect our cake. It will be eaten either way. Going back to the role of bar associations, the president of the Ethiopian Federal Bar Association asked this question. The easiest and the best way to market a farm or to build a cross-border network will be to come to an event like this. Here you will get someone from Morocco, you get someone from Algeria, Nigeria, Kenya, Tanzania, Uganda. From this very room, you can start a conversation that 3 months down the line, you'll have a network. You'll have someone you work with in Congo, for instance. You'll have someone you work with in Zambia, in South Africa, from this very room. And at the East Africa Law Society, we have something we call the Leading Law Firms Forum. Over the past 10 years, we have helped law firms that we can classify as leading law firms build over 20 partnerships across East African nations. I remember in 2017, a Kenyan gentleman came specifically to find partners. As we speak today, 6 years down the line, he has partnerships in Rwanda, he has partnerships in Tanzania, he has partnerships in Uganda, he has partnerships in Nigeria, out of participating in the Leading Law Firms Forum, where you are able to meet leading lawyers from other jurisdictions. And from that very session, we have seen groups like Let's Group grow. We have seen international law firms grow because they come, they find the best, they approach them, and they build networks.
I think I'm going to have to cut you short here.
I guess I have a lot to say because I am passionate and I do that.
You're totally passionate,
yeah.
And I appreciate that 100%. Which question we have not answered, which is probably quite key, is what is an international law firm? I might take that one as I think I introduced the concept. I think it's a term colloquially used in at least Southern Africa and East Africa, and to some extent in Nigeria and Ghana. If you say an ILF, international law firm, if you read studies on international law firms, there was one done quite some time ago by a consultancy called Redstone. Steve Blundell was the consultant. It typically describes Allen & Overy, Baker McKenzie, White & Case, big global law firms, international in their presence. They might have an office in South Africa for one, office in Casablanca, and that sort of puts them in the international law firm space. It's not a sort of defined more, there's no big definition. And why international law firms aren't African ones is just, it's just been a colloquial. Are you asking a question?
Yes. I want to explain. You know, the thing is, I'm an advocate for small practitioners, number one. And I think that we should, at least in my mind, I make a distinction between, quote, international law firms and practicing international law. And for me, you're practicing international law anytime that you have a legal issue which involves parties in more than one country. So that works for me. Can I quickly say something? Okay, with respect to the money that's going, I'm going to ask you a question too. With respect to the money that's going outside of Africa, it seems to me that one way to address this, and maybe one way to think about it, is that when you form these alliances and joint ventures with other law firms, that the fee structure might be on a percentage basis. So if the total billing for whatever the project is $1 million, and you're billing on an hourly basis, if you were to say, well, look, we get 30% of this, and you get 70%, 40%, and so on and so on, you might earn higher fees and keep more money in the country, in the content money. With respect to the NBA, I want to give 2 concrete examples which come within the definitions I just gave. And that is, I've been very active with lawyers in South Africa now for a long time. It's a very interesting story. But as a result of South African lawyers attending the NBA annual meetings, we've established these various relationships. Recently, one of those lawyers who attended our meeting, whom I've known for several years, called with an issue involving intellectual property. The claim of his client is that a company in the United States stole his client's intellectual property. And so what I did was to go through my NBA member chain to look up Ed Gray and some other people to form an intellectual property team to look at the issues that are involved in that case. That's still an investigation. The next thing is, with respect to class actions that I said something about a little bit earlier, there's another group in South Africa. We're currently looking at the question of bringing a massive class action lawsuit against financiers who finance activities that harm a number of individuals. And the premise for that grows out of several cases, and I'll just mention one, which may not sound like it's pertinent, but it is. In the Jeffrey Epstein case is down in the British Virgin Islands. J.P. Morgan Chase Bank has just settled 2 lawsuits down there, which allege basically that J.P. Morgan financed Epstein's sex trafficking activities, and they knew it. Now, the lawsuits were settled. One was for, they were both hundreds of $1 million in settlement. So that's a, but however, there are also other cases. There's a case, Jams versus Bupa or somewhere like that in India, where the lawsuit was brought against, I think, the IFC on the grounds that they financed these organizations. They knew that the projects that they were funding were going to harm a lot of people. They did so anyway. I don't know what the status of that lawsuit is at the moment. And lastly, last night as I was walking to the MoMA, I met a couple of young lawyers from Zimbabwe, and apparently there are some lawsuits like that that have come up in Zimbabwe or some other place. So that's a whole new area as well, okay?
I'm not sure if anyone wants to comment on the starting of the Alliance one. I've been involved in the start of the Alliance, so I'm happy to. But Yvonne, do you want to weigh in at all?
Yes, I just wanted to make a comment really in relation to advertising for legal work. Because I was a member of the Solicitors Regulation Authority in the United Kingdom about 15 years ago, when the question of whether or not firms could advertise, and the other question, whether firms could pay for legal work. They're called referral fees. And it was a really challenging issue for us lawyers, because the starting position is we are above that. We shouldn't have to advertise. And the work will come to us naturally. But the fact is that we have to move with the world. And advertising was being allowed in various forms. And so eventually the vote was no, we shouldn't. And then a year later they said, yes, we can. What I think as lawyers we need to do, we need to engage with the regulator who regulates, and then engage with the government, because the law has to be changed. And that's why I say it's important to be part of your regulator, your bar association, so that you can agitate for these changes. They will not come overnight. And if they are preventing you from getting work that those external to the country are getting, then you have to get together as a group and agitate for the law to be changed, if that is what you want. That's all I would say.
Thanks, Yvonne. I'm sorry, I'm getting a note that we're going to have to wrap things up soon. Okay, I still have to answer one or two. Okay, one last question and then some quick answers.
Sorry, my name is Khalid Bisnu from Nigeria, lecturer in Nigerian Law School. We are talking about trans-border alliance of law firms. What comes to my mind is when there is a question of ethical standard, violation of ethical rules. How do we discipline the affected law firms where the other partner is at fault and the other is not? Especially in Nigeria, that we have a new law ground that we can have a partnership, limited partnership and international organizations. Where in Nigeria, advertising, as was rightly observed, is prohibited under the rules of professional conduct. And my friend now from DRC is now saying that in DRC they advertise. So where a kind of relationship is established between a Nigerian law firm and one at DRC, and the DRC advertises and a law firm in Nigeria becomes liable, how do we come up with a regulatory framework to punish for ethical violations across the border? Thank you.
Walia, I'll hand that over to you.
Okay, so the first thing that you have to do when you do decide to enter into any alliance or network is to ensure that your entry into that alliance or network will not result in you breaching your local regulatory rules, right? So it's very important that before anyone advertises on your behalf, you are not, you don't allow it. So those would be the terms of your network or your alliance. And maybe just also comment here. In Zambia, we also had very strict advertising rules, but we had the publicity rules come in 2017, which then allowed for certain limited advertising. Because before we couldn't even have a business card, but now you can have that. You can have a website. You can, you're required to show if you're in an alliance. So those are some of the things. But when you're in an alliance, you have to comply with your local rules. So that if an action breaches that, you should not participate in it.
Yeah. Just on the question of a creation of an alliance, I was part of ALM, and as I say, I think they really are doing a fantastic job of spearheading an all-African alliance on the continent. And it really was the brainchild of a visionary lawyer from Kenya called Karim Manjawala. And he just had forged business relationships with lawyers in other countries and got them together around a table. They put together a memorandum of understanding which regulated the relationship. And it's a referral network with added benefits. And I can't tell you that it takes more than effort and a lot of sweat and blood to get these things off the ground, but it will pay dividends. And it speaks slightly to the question of advertising. And I was part of the business development team of ALM, and there are wonderful ways to advertise without advertising. And as lawyers, a cerebral bunch, your IP, what you produce, your knowledge, is you can put that out as much as you like. You can have alerts, this law has changed. Put an email out that says this is what's changed and some commentary. And if you've got questions, come and see us. You are able to publish in certain legal journals. You're able to go to conferences and be part of those. You're able to put up, promotions on your websites, etc. Do your very best within the means that you have, but because it's difficult and there are prohibitions, it doesn't mean you can't get started. I suppose, I'm very happy to share my details with everyone in this panel. You are able to reach out to me personally. I will give you as much information as I can on what I have done in my role previous to the one I'm in. And part of the role that I've now decided to be speaks to the gentleman's comments over there, that nothing has changed in 9 to 10 years. That figure of legal spend exiting the continent hasn't changed. and so many of the reasons why it haven't changed still present themselves. The international law firms, this label, they have questions on consistency across the continent. They've got questions on skills. They need to be educated to some part. But it's an invitation to all the managing partners and senior lawyers, and even just any lawyer within the firms here, to upskill yourself, reply to emails, give solutions, engage with your clients better. Yvonne, jump in.
Yes, I just wanted to make a comment, because in preparing for this seminar, I spent quite a lot of time looking at firms in the United Kingdom, and there are a lot of large firms seeking to form alliances with other firms on the continent. So if that is what you want to do, the hurdles are going to be quite high in terms of their requirements. I'm sure Boala will tell you what they require you to be able to deliver. So the requirements are going to be high, but there are many firms. I was surprised, there's a company called Africa Legal, many firms who are seeking to form alliances. So reach out to those firms in whether it's the United States or the UK. Those firms are looking for alliances. So that would be one way, rather than for you to do all the groundwork. Reach out, this is what we have to offer, would you like to form an alliance?
Panelists, I am well and truly out of time, according to this note that's been slipped to me, and even that was some time ago. I think everyone here on the panel will welcome a robust discussion over lunch or at the Avani dinner this evening. Seek us out, we would love to talk to you. Just in terms of housekeeping, I have 2 notices from Palu. Notice number 1, Palu members, please can you go stand outside the business centre. There's going to be a membership photo to be taken after the session. They are waiting for us. Oh, there they are. And then for those who have not yet paid for the gala dinner, you are still able to attend and to pay 50 US at the registration table. That's for the dinner tomorrow night. Everybody, thank you very much for this session. We're very grateful for your attendance, and all the very best with the rest of your Palu conference. Share those business cards and make your network. Thank you, bye.
J'espère, estime que l'usage des robots mènera inéluctablement au remplacement des professionnels chirurgicaux. D'autres estiment que l'intelligence artificielle ne fera qu'aider les professions du droit dans leur travail de tous les jours. Dans tous les cas, il est essentiel de réfléchir aux conséquences que l'émergence de ces technologies pourrait avoir sur la profession juridique. Sur la profession juridique qui inclut de nombreuses activités telles que le barreau, la magistrature, les notaires, les huissiers, les greffiers, les conseillers juridiques des entreprises, les services publics de l'État, parmi bien d'autres encore. Au-delà d'une approche purement théorique, notre réflexion s'est volontairement tournée vers la pratique. Cependant, la force est de constater que l'écart entre la théorie et la pratique demeure considérable. À titre d'exemple, l'imitation du comportement humain grâce à l'utilisation de machines automatiques capables de comparer que le langage naturel appelé robot ouvre de nouvelles perspectives dans le domaine juridique. Ainsi, il est désormais possible de créer des robots avocats capables de plaider, d'écrire, de parler, et de créer aussi des magistrats ou des juges aptes à trancher des litiges, des greffiers, des huissiers capables d'exécuter des décisions de justice rendues par des robots justes et bien d'autres encore. Ces avancées technologiques ouvrent de belles opportunités pour le développement de l'intelligence artificielle sur le plan juridique tel que nous l'avons pu le démontrer dans notre exposé. Pour chuter, cependant, il est impératif de considérer également les risques associés à cette évolution technologique En effet, nous devons prendre en compte la question de la responsabilité juridique, notamment en cas d'erreur ou de dysfonctionnement du robot juriste qui sera responsable. Les programmeurs ou les robots. Cette interrogation soulève véritablement les enjeux tant au niveau civil que pénal. En définitive, l'intelligence artificielle peut mener à une productivité efficace dans notre domaine d'activité, je cite le nôtre, qui est le nôtre, mais en somme, je prendrai en considération les risques qui va avec dans le domaine susténé. Mesdames et messieurs, les bâtonniers, estimés confrères, tel est l'essentiel de notre réflexion. Tout en réitérant mes remerciements, je n'ai pas la prétention d'avoir épuisé la recherche et je sollicite votre indulgence contre aucun lié à la forme. Je me remets à vous pour des objections, des questions et des remarques.
Thank you very much for that. I will now move to the third panelist. You will introduce yourself, and then I will go to Vanetta, who will also introduce herself, and then I will read each of the panelists' bios, and then we can begin with some starting discussions. So you can just state your name and where you're from, and then I will read your bios, and then we will begin the discussions.
Bon après-midi tout le monde. C'est Maître Nadège Kimba du barreau du Haut-Katanga en République démocratique du Congo. Voilà, je suis avocate et j'exerce depuis 5 ans.
Thank you. Then you can go to Vanessa Bang. Just unmute yourself.
Hello, fellow colleagues. My name is Vanessa Banks, and I'm from Chicago, Illinois. I'm past president of the National Bar Association, and I am so delighted to have this opportunity to join you for this very important discussion regarding the future of AI and its opportunities and risks. So thank you so much, Daladea and everyone, for having me today. It's such a pleasure to be here.
Thank you very much, Banks. We're happy to host you. Indeed, by you appearing virtually is a testament to the use of technology in practice. So yeah, I'm very happy to have you. I will read briefly bios or biographies of the respective panelists, and then we shall go into the discussions. I will start with my immediate right. We have Mr. Paulos Adimas. Mr. Paulos Adimas is a lecturer at the prestigious Nigerian Law School, which is a vocational institute for the training of graduates in the Nigerian law faculty. He has 15 years of cognate experience. He's a skilled and highly regarded litigator in Nigeria with expertise in civil litigation and property law practice. He's a prolific author and is widely published in Nigeria and international journals. He practices and teaches the law in the area of the interface between legal practice and technology. And so this really falls squarely within his purview. Next to Dimas, we have Marti Ruth Mayuba. Sorry, but she read it because clearly it is in French, and we're happy that she read it for all of us. We then have with us Vanetta Banks, who has joined us virtually. Vanetta is an accomplished senior executive in privacy and cybersecurity attorney and a counselor to financial services, insurance, biopharmaceutical industry sectors.
She provides strategic advice and counsel on data protection and cybersecurity matters, including the renowned EU GDRP and the CCPA. In her role as Global Privacy Counsel, she has extensive experience counseling business operations regarding disruptive technology, including, and this is interesting, drones, autonomous car, mobile devices, big data, blockchain, the Internet of Things, predictive analysis, and artificial intelligence. She specializes in complex insurance, employment and class actions, litigation. She also specializes in technology and commercial transactions. And she teaches cybersecurity and privacy law at a college introduction to law course at Michel Hemlin School of Law. She is a trusted advisor to C-suite executives. She has extensive experience developing and implementing global risk-based data protection and cybersecurity programs, including corporate policy for electronic communication and commerce. She has led the information technology team that established All-Light Insurance Company, which is a multi-million e-commerce business. She has received the highest employee award, which is called the ALISA Chairman's Award for her team leadership and superior performances. She is a relentless and early advocate of diversity and inclusion in different disciplines within the law. Previously, she has been the president of the National Bar Association. She has served as the 65th president of the National Bar Association in the US, the oldest and the largest national association of predominantly African American lawyers and judges. Vanita has served as the chief executive officer and spokesperson for the second female attorney in America. Shortly after taking office, she has held meetings at the White House Council advocating for African American judicial nominations and for the justice of the Gen 6. And we are delighted to have her with us today. In the course of our presentation, I will read the bio to our final presenter, but in the meantime, we're happy to begin. So, to set stage, the question of artificial intelligence is a grave one, for the reason that as lawyers, we see it coming, we see it creeping. For dispute resolution advocates, particularly, we have been inspired by the tides of time. But for commercial and comprehensive practitioners, we see it directly affecting them in terms of how they operate, in terms of the generation of documents, and generally its application to what they do. And so it is a welcome move to have this discussion here with us today and try and see, as lawyers, especially in the African space, how do we deal with this issue? What are the risks that we intend to face, and how do we tap into that ever-emerging and ever-changing landscape? The purpose of this discussion today should be three, and then these are the things that we'll discuss primarily. First, we will talk about artificial intelligence and its application in the legal sector. We shall then examine the benefits that has come as a result of artificial intelligence in the legal profession in Africa, and then look at the potential risks and ethical issues that have arisen as a result of AI involvement and application in Africa. And then lastly, we shall have discussion as to how, as practitioners, we intend and how we can benefit from these emergencies as a result of AI. So I'll just begin by my immediate right. I will pose a question and then I will pass the mic around for different panelists to give their thoughts. And so I'll begin with my colleague Dimas, and particularly to give, in your view, what are, in your view, the implication of AI in the profession so far?
then the context of Africa, and possibly giving a mention to Nigeria, which is the jurisdiction. And then we will go around.
Okay, good afternoon. Like the moderator rightly said, the revolution in artificial intelligence has come to stay. And it has a ripple effect on virtually all professions, in medicine, in engineering, in the legal profession. And it is a revolution that it is either we key into it or we are left behind. And in the analog way of doing things, it's no longer acceptable in the 21st century. Even though the legal profession is a conservative one, we have to adjust with the season. And artificial intelligence has come to stay. We now use machines to carry out tasks, execute tasks that require a cognitive human intelligence with precision and with all mathematical accuracy. And it has come to stay even in the legal profession because we apply artificial intelligence now in virtually everything. We use it for contract analysis. We use it for prediction of outcome of cases. We use it for research. And we use it also, to in risk assessment. These basically are what lawyers do. We draft contracts for parties, we analyze contracts, and then it involves the use of a lot of papers. We don't need to go through all those papers one by one. Artificial intelligence has come to help us to streamline, to analyze these documents with precision and to tell us exactly what we need. So it has come to stay. But as lawyers in Africa, the question is how prepared are we to adopt or to leverage on the opportunities that artificial intelligence comes with. So it is very, very important for us as lawyers that we key into it. And let me allay the fear that a lot of people say artificial intelligence has come to take over our job. It has not come to take over our job. It has come to help us to improve our job, to do it even more better. Because artificial intelligence cannot take over our job. It is lawyers who have adopted artificial intelligence that can take over the jobs of lawyers who are recalcitrant to the modern times and seasons. So it is very important that we leverage on that and then we tap into the opportunities. Thank you.
Thank you very much, Dimas. You set a very good bar, and you set stage for the discussion that will follow. I want to move very quickly to the US to hear from Ms. Juanita Banks. Juanita, I know that you're an expert in this area, both in academia, in practice, and also in writing. And we're happy to hear some of your thoughts about it, particularly what you think the legal sector should look out in terms of AI. Briefly talk about the risks and also the opportunities that come out of it. Take it away, Anita.
Thank you so much again for this opportunity to join you today. And I just wanted to say from the outset that I focused my career at the intersection of law, technology, and public policy. And throughout my career in the insurance, financial, and pharmaceutical sectors, I've advised and counseled information technology professionals on developing and implementing systems to achieve our business objectives. And that is from, and our esteemed colleagues and panelists know, from the legacy mainframe systems to now the cloud. Let me give an example example, the insurance industry has long used big data sets and algorithms in the underwriting of insurance risk based on predictive analysis. And so I've had the great opportunity to provide legal advice and counsel to cross-functional teams that took our insurance business, for example, online, and had an opportunity to draft some of the first privacy and data protection policies. Currently, I advise business clients on developing and implementing data protection and cybersecurity programs that must comply with a myriad of global laws, including GDPR. And my work now, as many as our panelists, is focused very closely on AI, which, as you know, and my colleague just stated, that AI is not new, and it dates back centuries. But recently, AI has been, at least here in the United States, thrust into the public eye when ChatGPT and other generative AI products were recently announced. Artificial intelligence, one way of thinking about it, it's a process of using big data sets to teach and instruct computer systems and machines to mimic the problem solving and decision making of humans. And of course, those systems can perform some tasks, as my colleagues stated, exponentially faster than humans. As I was researching this topic for today, I discovered that over a century ago, in 1897, a U.S. Supreme Court Justice, Oliver Wendell Holmes, prophetically wrote, "For the rational study of the law, the black letter law, man must be the man of the present, but the man of the future is the man."
Il y a une interférence, excusez-moi.
Sorry, Vanessa, we lost you there.
Principles. The field of law is also based on predictions of how past precedent will apply to a current set of facts. However, the legal field has been very, very resistant to change, and as my colleague stated, very conservative and resistant to embracing new technology. In fact, the law often lags far behind technology. However, as my colleague stated, artificial intelligence is here to stay, and as lawyers, we must begin to adapt and embrace it. In fact, as he stated, artificial intelligence is transforming and disrupting every industry, sector, and the law field is no exception. One of my colleagues is using drones in his personal injury practice. We know that drones are being used to transport needed medical supplies to Africa and countries across the world. The title of our program is Artificial Intelligence and the Future of the Legal Profession. Let me just say that the future is now, and that the transformative change driven by AI and innovative technologies is here to stay. We're already seeing it used, as my colleague stated, in legal research, In fact, with the new chat GPT, it will replace the old Boolean queries with natural language processing. In contract review, management and administration, we're seeing contract acceleration and intelligence platforms reviewing voluminous documents in litigation. For compliance and due diligence purposes, we're seeing AI and machine learning applications. Generative AI, colleagues, is a game changer, and it's currently being used by attorneys. It cuts down the time and the repetitiveness of reviewing voluminous documents. It is being used to predict the outcome in a litigation. However, the use of AI tools does not excuse a lawyer from their ethical responsibilities of submitting accurate and complete briefs to the court. You may have read about a New York lawyer who's currently facing sanctions for filing a brief in court with made-up cases and citations produced by a hallucinating chat GPT. And so while there are many, many benefits, and as my colleague stated, a machine will never replace the critical thinking skills of lawyers. The ability of a trial lawyer to tell a persuasive story to a jury. AI should be used as a tool to facilitate our work and hopefully to free us up to spend more time with what we do best, which is innovative, creative, strategic work with our clients in addressing the problems that they face. Thank you.
Thank you very much, Benita. Thank you, Benita. Thank you, Benita. That was quite insightful. I hope you can hear me, Benita. I will move to my next co-panelist, particularly talk to us about what, in your view, is the application of AI in the legal sector. Feel free to give us your experience in the DRC Congo around the same topic.
Mesdames et messieurs les bâtonniers, honorés confrères et estimés confrères, mesdames et messieurs, permettez-moi de vous exprimer toute ma reconnaissance pour l'opportunité que vous m'avez offerte aujourd'hui. C'est avec un grand honneur et un plaisir immense que je m'adresse devant vous tous en tant qu'avocat du barreau de Kinshasa-Nalité. Eh bien, je suis maître Maya Bosson. La question qui m'a été posée aujourd'hui et dans cette conférence est celle de parler sur l'intelligence artificielle, son impact sur l'opportunité et les risques. Il convient de s'interroger sur les perspectives qui attendent les avocats, les magistrats, les huissiers, les greffiers, bref, le personnel juridique face aux robots capables de remplir les mêmes tâches qu'eux-mêmes exécutent. Le domaine juridique, à l'instar des autres sciences, se base sur l'intelligence humaine, les cerveaux humains, la connexion, ainsi l'intelligence artificielle, qui ressort à l'intelligence humaine représente une évolution majeure pour la profession juridique. Bien que certains des experts estiment que l'usage des robots mènera inéluctablement au remplacement des personnels juridiques, d'autres estiment que l'intelligence artificielle ne fera qu'aider les professionnels du droit dans leur travail tous les jours. Dans tous les cas, il est essentiel de réfléchir aux conséquences que l'émergence de cette technologie pourrait avoir sur la profession juridique, qui inclut de nombreuses activités telles que le barreau, la magistrature, les notaires, l'huissiariat, les greffiers, les conseillers juridiques, les entreprises, les services publics et l'État, parmi bien d'autres encore. Au-delà d'une approche purement théorique, notre réflexion s'est volontairement tournée vers la pratique. Cependant, force de constater que l'écart entre la théorie et la pratique demeure considérable. À titre d'exemple, l'imitation du comportement humain grâce à l'utilisation de machines automatiques capables de comparaître le langage naturel appelé robot ouvre de nouvelles perspectives dans le domaine juridique. Ainsi, il est désormais possible de créer des robots avocats capables de plaider, d'écrire, de parler, des magistrats capables de trancher des litiges, des greffiers, des huissiers capables d'exécuter les décisions de justice rendues par les robots juges et bien d'autres encore. Ces avancées technologiques offrent de belles opportunités pour le développement de l'intelligence artificielle dans les professions juridiques telles que nous avons pu le démontrer dans notre exposé. Ces opportunités, spécialement de l'intelligence artificielle dans les professions juridiques que nous venons de démontrer, seraient le côté phase. Les risques de l'intelligence artificielle dans ces professions seraient le côté privé. Cependant, il est impératif de considérer également les risques associés à cette évolution technologique. En effet, nous devons prendre en compte la question de la responsabilité juridique, notamment en cas d'erreur ou de dysfonctionnement du robot juriste qui sera considéré comme responsable, les programmeurs ou le robot. Cette interrogation soulève de véritables enjeux tant au niveau civil que pénal. En définitive, nous souhaitons faire valoir le respect de la loi, car l'intelligence artificielle n'est pas destinée à faire disparaître les professions juridiques, mais plutôt, elle permet de renforcer l'efficacité du travail de ces professionnels. Ainsi, l'intelligence artificielle et l'être humain peuvent collaborer pour donner un sens à la technologie. Tout est question de la manière dont nous utilisons la machine dotée de l'intelligence artificielle afin de bénéficier des avantages qu'offre sans subir les risques qui se sont associés dans nos professions juridiques. Car il est crucial de rappeler que l'intelligence artificielle est une invention de l'être humain et qui appartient donc à l'homme de décider de son avenir. Mesdames et messieurs, les bâtonniers, messieurs, honorés confrères, chers estimés confrères, mesdames et messieurs, tel est l'essentiel de la réflexion. Tout en réitérant mes remerciements, je n'ai pas la prétention d'avoir épuisé la recherche. Je sollicite votre indulgence contre vos qui liés à la forme. Je me remets à vous pour des suggestions, des questions, ainsi que quelques remarques. J'ai dit.
Thank you very much for that. Indeed, that is also quite insightful. And now I will move to my father right, Ms. Kimba. Ms. Kimba, just give us, in your view, what are the applications and implications of AI that you have experienced so far in the legal sector? Feel free to wade into disputes, into commercial practice, into financing practice, generally how you think has evolved.
Bon après-midi tout le monde. Je constate que la salle se